running the show. Marissa is the mod, we have nice mods too. Jamima gets the docs, don't you know? They're the ones yelling at Baker all day. Yelling at Baker all day. Hey, hey, hey. Yelling at Baker all day. Hey, hey, hey. Yelling at Baker all day. Hey, hey, hey. Making sure he hears what they say.
Good morning, good evening, good afternoon, wherever you are, whoever you are. And why is it showing comments on stage? Because I don't like that when I have to read. Welcome one, welcome all. Tomorrow, Kelsey will be back, as I said earlier, in family court. So far, my super team of crack detectives haven't been able to find out if anyone is gonna make a feed available. There is no official court feed, but we have a mother's verified opposition to father's verified motion for further temporary orders. It rolls right off the tongue. This is, if you remember, I read Justin's complaints about Kelsey and why she shouldn't have more than, was it 2 hours, 4 hours custody with the kid, and all of the bad stuff about her. She was a drunk, she was violent, she was all of the bad stuff. This is the reply to this. And as Barbara alluded to in chat, if you didn't see it, in this motion, it is disclosed that she have had 2 hours with baby C at his lawyer's office under supervision of Alien and his lawyer team. So, baby steps, and what a great day for her. No matter that it was in those circumstances, that environment, I'm so happy that she got to see her baby again. So, yeah, that is that's one of the good things that we're going to talk about. And I have read parts of it. I didn't read the full. It's 25 pages, so it's going to be a little bit of a longer. I think, was it Britt yesterday who talked about the actions? Maybe it was Lauren who talked about the actions you have to take to show willingness to cooperate. And we will hear a lot about that in this motion today, because there will be some case law mentioned as well. So Kelsey should be bringing her lawyer, but that's just my opinion. I don't know if her lawyers were present. I just read that she has had 2 hours with her son. I don't know, other than father and father's attorneys were there. So, but yes, I agree with you. Tape it, record it, have a lawyer present, have a witness, just to make sure that nothing is being used against you, because it was some pretty severe allegations that was made against Kelsey Fitzsimmons in Aliens Motion. So she needs to be very, very careful with everything. Kelsey seems to have a good team. I'm sure her lawyers were there. Yes, but or at least bring your mom, bring your dad, bring someone who can witness everything, so no one can make allegations about you. Sorry, just got a message about this. Courtney may have gone with her. I'm sure she wasn't alone. Again, that would be pure speculation on my side. I just read it, and I got excited, and I wanted to come share it with all of you wonderful, wonderful people, because now we can't watch it tomorrow. At least we know a little bit about what they're gonna talk about. And the introductions and the relevant background is, as we know it, they were never married. They had one minor child, and they resided together between March 2024 and June 27, 25 at Phillips Brook, the home owned by mother. On or about June 27, 28, father voluntarily vacated the North Andover home, leaving mother with their infant son, then 4 months old, until June 30th. Mother is now residing in, we don't need to see that. Just going to take this off because her address is here. Mother has paid a full year's rent for stability of this residence for herself and the party's son. This home has full bedroom for their son, decorated and designed for their just for their 14-month-old baby. So she has already started to make a home for her and the baby. Father currently resides with the child at his parents' address. I'm just gonna, because I haven't blurred this out. It's public, but still, we don't want anyone to claim that anyone has done anything, because we have done this. Where he resides with his parents and has no residence of his own. It's unknown if Caden has, Baby C has a room of his own. Thank you so much, Hellfish, for gifting 10 memberships. And they went to Brenda Lord, Blinky, Objection, Your Honor, Becky Slaughter, Pamela the Camel, Rainy May, Laurie Ballou, Miss Brown, T-Rex, Full of Questions, Barbara, all got a memberships. Thank you so much, Hellfish. And yes, very good to hear. Thank you so much, Annie. Thank you so much. Which will be mentioned in all of this as well. On or about November 7, mother sold her home in North Andover in order to afford legal fees for her 2 pending legal cases and to pay for costs associated with her son that she willingly wanted to provide. Mother agreed to put $50,000 into an account for the child, from which father withdraws funds to receive child support and mother's share of the child's uninsured medical cost and agreed upon activities. Said funds were deposited into an account held by father's counsel, and said account is being utilized in that fashion. Said plan was created during a time when mother was in custody and unable to readily access her bank account, readily receive communication about their son, and readily assist in decision-making for their son while mother was in custody. All that has since changed, but the order remains in place for the time being. So I know some have speculated about who managed those $50,000 that was agreed upon. It seems everything is going by the book, and the fund is only being used for what it's used for, not making a new deck or something. Father is employed as an EMT firefighter with the North Andover Fire Department and is currently on administrative leave. There has been no update to his financial statement or discovery to know what type of leave, how long, and whether it is paid or not. So we don't know if he can provide for the kid. Mother was formerly employed as a police officer at the North Andover Police. On July 14th, mother was placed on administrative leave, and she resigned in December 25. Mother is not currently employed. That counts a little bit against her. Although father obtained a 209A abuse prevention order against mother on June 30th, father has since dropped the portions of the 209 that are in any way related to the child, including contact and custody. Father has also dropped the stay away and communication provision between the parties. The ongoing provisions is a no abuse provision, which the parties has agreed will remain in place for 3 months, after which time, presuming no violations, the entire 209A will not be extended and will be vacated by operation of law on the return date of July 30th. There was never a two-party hearing on the 209A, and mother refutes all allegations made against her. It was mother's choice to enter into the stipulation of April 14th rather than continue to fight father in court and force the parties to engage in additional litigation against one another right when they needed to be co-parenting for the sake of the 14-month-old son. This is, I think it was Britt Happens who said this yesterday on Masa's show, that it's really important in these kind of cases to show your willingness. And they are pointing out that she has done whatever she can. She's willingly giving them money. She's vacating the order so you don't have to fight in court. That is okay. Well, we're just reading her motion, so that's... Det er helt okay. Det er helt okay. Du er svensker. So she is putting all the right words in, that she is doing what she can to help. The day after father initially applied for the 209A on July 1st, 2025, father filed a complaint for custody support parenting time pursuant to MGL C209C. Father amended his 209C complaint on August 8th, 2025. Mother answered with amended complaint on October 22nd, which included mother's counterclaim. On June 30th, during the service of the 209A on mother did raise a gun to her head in an accurate transition psychological crisis, report of Dr. Seisel. Her whole world came crashing down on her in one moment. When she faced the loss of her newborn son as he was being taken from her right in front of her eyes, loss of her fiancé, complete betrayal by the man who was supposed to be her support partner and future husband, potential upcoming loss of her job due to the 209A, loss of her home if she could not afford it once her fiancé left, and loss of her life as she knew it. Due to raising a gun to her head, she was shot by fellow officer at North Andover Police Mother was immediately transported to Massachusetts General Hospital, where she spent 53 days recovering until she was transported to the Western Massachusetts Regional Women's Correctional Center after having been charged with one count of assault by means of a dangerous weapon in Lawrence District Court on July 3rd. On March 12, 2026, even before the trial on the underlying criminal actions, the Superior Court, Judge Karp, issued an order amending the condition of mother's release as follows. Inter alia, strike requirement that she resides with her parents, strike requirement that she stays away and have no contact with her child. On March 26, Superior Court Judge Karp found mother not guilty of assault by means of a dangerous weapon. Months prior to that verdict, however, the parties had entered into a stipulation on October 21st, wherein, for purposes of this opposition, father would have sole legal and physical custody of the party's son. At that time, however, mother was in custody, had no ability to communicate with father given the Superior Court orders and the 209A that father had obtained against mother. As such, mother had no choice but to agree to those conditions or make futile arguments at a motion hearing, wherein the court would have clearly granted father sole custody at that time based purely on circumstances, as decision for the child needed to be made without being hampered by lack of communications between the parties, given that mother was in custody at the time and she faced criminal charges with no trial date set at that time. Mother was also still recovering from almost fatal injuries. Again, it's not because I didn't want to interact with my kid. It's not because I gave away my legal rights. It's because I had no way of participating in my child's life. On March 10th, mother filed a motion for further temporary orders and an affidavit in support thereof, hopefully anticipating the criminal trial's not guilty verdict and wanting to move forward with a co-parenting plan. The hearing on her motion was initially scheduled for April 2nd, but given the criminal trial was not scheduled until March 23rd and opposing counsel was not available on April 2nd, the hearing was moved to April 23rd. The court informing counsel and parties that this matter would be moved to Lawrence before Judge Ulwick moved the hearing to April 28th. So that's the one tomorrow. Now there has been substantial changes in circumstances since that stipulation of October 21st, which mother seeks to address and modify the existing temporary orders for access and decision-making authorities with father relative to their son. A, the Superior Court restrictions relative to the party's son was vacated. Mother was found not guilty of the charges against her. The 209A no longer restrict the party's communication or the contact with the child, and mother's mental health is stable and she no longer suffers from postpartum depression. That is also really nice to hear. Father's response to mother's motion was not to attempt to reach any reasonable agreement, but rather to file his own motion for further temporary orders, vitriolic in its allegations and spewing a clear inability or desire to co-parent. And this is what we're talking about. Make sure the judge know you do everything, they do nothing. And a motion for GAL, guardian ad litem. As is alleged herein, it is father who cannot co-parent with mother, and he creates a narrative around mother's brief 2025 postpartum struggles in order to still keep her away from their infant son almost 1 year later. Nothing could be more egregious at this point, and nothing speaks more than a father who cannot share custody or parenting time with a mother who has not seen her infant son since June 2025. On April 25, father allowed mother to see baby C for 2 hours at his counsel's office, supervised by father and counsel. He has not allowed other contact or communications at any time. And I think that's really dumb. Hey, Lauren. Good news, she got to see baby C on Friday. But this is really dumb because tomorrow they're going to go to court and Alien is there to say, well, I really wanted to make everything happen. Of course, she has to see her baby. Yeah. But he hasn't shown it. I think this is really dumb by him. Because she can now use that against you. Why haven't you set up that she can FaceTime the kid every night before bedtime? Just to get to know him, or maybe twice a week. Some of these very easy little things you can do in these situations. Instead, no, you have to be in my lawyer's office, and that's all. That's I think that's a mistake on their part. I haven't been in an American custody battle, so I don't know how it is. But that's one of the things. Cell phones were pretty new and to be readily available when I got divorced. But that was one of the things that we were encouraged to do. If the kids wanted to call, make them call. FaceTime wasn't existing at that time. But just make sure if they wanted the other parent, don't withhold it from them. And we actually was asked about it in court if they had been willing to do it. I was going to say, why once a week? Well, whatever. Maybe it's a little overwhelming for the baby to do it every night, but then a couple of times a week or whenever he asks for it. I'm just saying it's such an easy little thing to show court that you are actually willing to co-parent. It should be noted, too, that father has not allowed mother's family to see this child either, other than mother's sister attending the child's baptism. This child is being ripped from an entire side of his family, and it certainly does not serve his best interest to do so. Bravo, pointing out it's not in the kid's best interest. Mother seeks to simply share time and decision-making with father, but father's vitriolic and self-serving opposition should be a red flag to this court. You go. Just point it out to them. Father has pointed to no single piece of evidence where mother has ever harmed their son, attempted to harm him, or where he has ever been injured when in her care. None. Father's behavior is aimed to punish, not protect. Really, so far, really good, in my opinion. Relevant law. Although there may be some conflict between parties, joint legal and physical custody may still be appropriate if the conflict concerns the parents' own relationship rather than be in specific areas of disagreement regarding the children's care, custody, and upbringing. Doe v. Doe, Roldy v. Roldy. True joint custody is divisible into two components, shared legal custody and shared physical custody. Shared legal custody carries mutual responsibilities and involvement by both parents in major decisions regarding the child's welfare, including matters of education, medical care, and emotional, moral, and religious development. DLC 208, Mason v. Coleman. The best interest analysis is a child-centered one that focuses on the specific needs and interests of a child and how these might best be met. EKVSC. Citing Charada v. Yantim, if anyone wants to look it up. In custody matters, the touchstone inquiry is what is best for the child, and the determination of which parent will promote a child's best interest rests within the discretion of the judge, whose finding must stand unless they are plainly wrong. EKVSC, Malachi v. Quintina, and Hunter v. Rose. The judge shall consider whether or not the child's present or past living conditions adversely affect his physical, mental, moral, and emotional health. EKVSC. The insurance of an order under 209A shall not in or of itself constitute a pattern or serious incident of abuse, nor shall an order entered ex parte under said Chapter 209A be admissible to show whether a pattern of serious incidents of abuse has in fact occurred. MGL 209C. So that's the case law they want the judge to think about. Alien is just showing how much an a-hole he really is, not sure how much pull he has with the family court judge, so it may not matter. It didn't matter to the cops. That's the problem. That family has some connection. In my opinion, I don't know it. I wish someone who lived a little bit closer could go out and sniff if there's any dirty laundry that kind of like when we found out that Proctor was the McCabe's second family. If contact went well, it should be alternate days. Now Baby C has seen her. Consistency is paramount at this stage. Yeah, they need to get into some kind of rhythm. And this is why I'm saying, if you want to game the system, you allow her to have FaceTime calls with him every night for half an hour or something like that. And then she can have a sleepover every other weekend. That would show the court that you're willing to participate. And of course, she has a right to see her baby as well. This is what most men would get in these cases. But as they're rightfully pointing out, this has nothing to do with what's best for the baby. This has to do with them controlling the baby and access to the baby. I read, this is a response to the papers I read, I think 2 weeks ago. I wouldn't, Willingness to cooperate and co-parent. While father cites in his motion the case of Macri v. Macri and Mason v. Coleman, which provide that for joint custody or shared responsibility to work, both parents must be able to want to cooperate in making decisions for their children, and that the parents must have a willingness to work together. Father has not shown his willingness to do so. See 96 Mass Appellant Court 362, 369, 2019, 447, Massachusetts 177, 206. In fact, the evening after the 209 restrictions about the parties' communication and contact with the child was vacated, mother immediately opened an OFW account, messaged father on April 14th and again on the 26th, sending him the link to connect to OFW twice, and offered to pay for his OFW account. Both parties had suggested OFW as the best form of communication moving forward. See parties' filings. Father not only failed to open his OFW account, even as of this filing, but had blocked mother from communicating with him via text message, which was only learned on April 21st. Despite mother first suggesting OFW, then father also suggesting it in his instant motion filed on April 3rd, father still will not create an OFW account to communicate about their child. It begs the question, what was the point of vacating those provisions from the 209A if father is simply going to ignore mother and block her in every way from communicating? Yes, it's called Our Family Visit. It's some kind of messaging scheduling program you can have so you don't have to communicate via text and stuff like that. So you can make some separation between the parents. But again, why don't you just do it? It's stupid. What is clear is that father is the one who is unable to cooperate in making decisions for their son and have any willingness to do so. Contrary to the Marcy v. Coleman holdings, mother should not be the parent who is excluded from decision-making or parenting time because father cannot co-parent or even open the lines of communications. Yes, this is the smart thing. Instantly go home, set up the account. Give him the opportunity to not cooperate, which makes him look like an asshole in the eyes of the judge. On April 18th, counsel for mother email counsel for father detailing this issue and expressed how concerning it is that father will not even open an OFW account, despite seeking it in his own motion filed with the court. Mother, through counsel, even agreed that no OFW message would appear on social media per father's request in his motion, but there was still no movement by father. Father himself argues in his motion that the parties must work together to ensure that all decisions are made after a meeting of the minds between both parents. See page 8 of his motion. Father has made working together or having a meeting of minds impossible by blocking mother and refusing to open the OFW account. Hey, Lieutenant Detective Tolly Tuppy. Have they actually appointed a GLL? I know some questions had come up about it not really being beneficial since he's so young and can't communicate. Maybe Lauren will have that answer because I am sorry, I don't know. The aliens will use Baby C as support as much as they can, in my opinion. Yes, they will. And they will control access to him in a way to punish her for hurting little Justin Boo. Well-being of the child. Father argues that he has been the primary caregiver for 9 months and should therefore remain in that role. What father fails to recognize is that he's surreptitiously, I can't say that word, someone spell it out for me, please. Surreptitiously. I know my mods are yelling at me right now. Why do they need this number? Surreptitiously. Set up that scenario by obtaining a 209A based on false allegations. That false nature of those allegations are addressed herein more fully. In addition, father fails to recognize that mother, due to the mistake of the North Andover police and the postpartum mental health of mother at the time of her life, was collapsing in an instant. Mother was accused of assault with a dangerous weapon, which resulted in her being in the hospital through August, then held in custody and waiting trial, initially, until late December, then released from custody in December to reside with her parents in Methuen for house arrest through the criminal trial when she was found not guilty in March 2026. When mother was released from custody, father refused to allow mother to see their son in any capacity other than through 2 emails per month, which shares limited information and photos of their son through counsel. Mother would have had no ability to fight for any parenting time, giving her then pending criminal trial. The issue is that mother had a Fifth Amendment right against self-incrimination, which would have had to have been waived in order for her to defend herself and argue the salient points of father's myriad allegations against her. Essentially, mother was faced with a catch-22 and a no-win situation to fight these simultaneously pending court battles. Mother had to rely on father's goodwill, good faith, and good character to even see her son at any level, even Zoom, FaceTime, or a supervised visit. We all know what father chose, to say no to mother at every turn. So the fact that father relies on 9 months of caregiving without mother's participation is a product of his doing and his choices to keep mother apart from her growing baby. Father can claim it was in an abundance of caution to protect the child, but the fact we all know very well in family court is that there are numerous ways to keep a child safe, while also opening up the mother-child connection. Father simply took advantage of mother's catch-22 position, unable to defend herself from drowning under the 209A, which resulted in an inability to seek parenting time with her own son. While mother's mental health was surely a concern, there were ways to work through that collaboratively, but father refused. It is not disputed that, based on the limited knowledge mother has of Baby C, sent through attorney emails with updates and photos, Baby C is healthy and meeting developmental milestones. Mother is not alleging anything contrary to that. Mother is simply seeking to see her son and be involved in his decision-making, which is the presumption of this court's absence other factors. Good again. I'm not demanding, hey, he's kicked out of the baby's life. I just want to see my baby. And I believe he has been a good father for him while this has been going on. I really like the tone in this motion so far. It is astounding, though, that father can even suggest that their son is thriving when he is and have been without his mother. Such a statement is, in his motion, reflects a true absence of understanding of early childhood, the best interest of the child, and any respect for the role of a mother in a child's life. Remember, the hearing was the one where he said that his doctor told him he was the greatest dad in the world. That's the one this is a reply to. We yelled a lot about that one. He only let baby C see mom last week, so the courts won't say dad is denying access. The problem is, and this is why I believe this is a good writing so far, he has played all the cards and he has refused to take them. Because she has opened up the communication. She has used the platform of communication that he demanded, and he has not responded. Not even after his counsel. And that's when I'm starting to think, how smart is his counsel? Why didn't his counsel tell him, yeah, just open it. Just open it to show your willingness. It is preposterous to believe that the party's son is thriving without his mother. Father's recitation of what he does with or for their son is basic parenting. While he can be credited with doing exactly what he should be doing as a father when it comes to basic support of a child, it does not mean that the other parents should be excluded from the same ability to parent a child. In January 2026, mother asked to send a care package to father for their son. He refused to allow her to do so, citing the 209. The fact that father's behavior has been only to keep mother sidelined speak volumes and is unwarranted. Again, your battle with your ex is not your child's battle with your ex. He is so dumb. Yes, exactly. Both sides should keep a journal. Today I tried to call, she didn't answer. Today we had FaceTime. Baby C was very fussy and didn't want to talk. We agreed to try again tomorrow. Simply keep a journal of all of these things to make sure no one can come and claim you are not participating in it. You have to say that as one of Hank Breenan's students. Provider involvement and professionals to assist father in parenting, including the pediatrician's commentary out of context from records that father refuses to share with mother due to him having sole legal custody under the current orders, is simply hearsay and should not be considered by this court. Father alleges that the pediatrician commented that their son is doing well, particularly due to him living with father and father's family in Stowe. A pediatrician would not make such comments out of context. In what other environment would the child be living in comparison? Yeah, is it in Mumbai, India, or what do you compare it to? What question was posed to the pediatrician for such commentary to be made? Did the pediatrician comment that the prior home was insufficient? There are more questions created than are answered by this commentary in his motion. Without the full clinical note or understanding the context, this comment makes little sense and yields nothing in terms of whether mother should be awarded parenting time or shared legal custody. In my opinion, it actually does the opposite. By putting that one in, hey, I'm the greatest dad in history. I got the world's greatest dad mug. It just shows you believe a lot about yourself, but you don't show it. You don't, it's so easy. Just give her some access to the child. The fact that father refers to an early intervention specialist having worked with their son since July 2025 is shocking. This was never disclosed to mother in any of the bi-monthly updates. The only mention of it was as follows on 10/29/25, as follows. Baby C's surgeries was scheduled and completed in September. They fixed a hernia on the right side. Doctor stated everything went well and there is a very small likelihood it will cause any problems in the future. He is up to date on all scheduled vaccines. Early intervention was recommended due to the trauma he sustained, which is a state-run program, and they come bi-weekly to ensure Caden is meeting his developmental goals. Not only is this report inconsistent with what father has just reported in his motion, but father never again updated mother about these visits. Father also did not say he had already begun that specialist's involvement by October when he reported it had been only recommended, but his motion indicates it had been started months earlier, as early as July 25. Father also failed to provide the 3/31/26 update to mother and did not share the letter, but offers it here to this court. It is questionable why father could not share that with mother via counsel, per the October court order, and it's questionable why it was written, other than clearly sought for the purpose of litigation. He's such an asshole. I'm sorry. Father continues citing commentary by this specialist, but mother has access to no records, has been shared no records, nor has she ever, before father's instant motion, been shared the name of this person. The commentary appears to be generalized updates that the child is doing well, which is wonderful, but it begs the question as why these records has not been shared with mother, and what progress is being considered. It is laudable, not laughable. It's laudable that father has done well with the child, but this specialist has only had contact with the father, and it is questionable if this specialist is even authorized to comment on a child's well-being when the mother is excluded from his life. Clearly, father feels he must buttress his fatherhood with approval from others, but it still has nothing to do with whether mother should be allowed parenting time and sharing decision-making of her only child. Again, mother seeking involvement with her child is not saying father is a danger to the child. I like that he must buttress his fatherhood with approval of others. I think that's really, really correct. I believe Justin Alien is a little man boy who needs constant pats on the head and being told, "You're such a good boy. Oh, you took care of your own sexual byproducts. Oh my God, I'm so proud of you. Oh, you changed the diaper. Aren't you a big boy?" Apparently, this specialist also made recommendation for even more additional specialists for the father, as he could not care for the child properly, as he needed further help and support from 2 additional professionals just to feed the child. While it is applauded that father sought support when he felt he needed it, this is precisely why mother should be brought into the picture. Mother had no problem learning her son's cries voices, which Miss Romero wrote was part of her job for father, feeding him and caring for him when she was present during the first 4 months after birth. While things changed over time and the child's needs changed, father should be including mother in seeking assistance with the care of the child, not excluding her and seeking outside sources when it's clear he needed help. Moreover, father never informed mother of these additional professional recommendations, nor did he inform mother he actually hired 2 additional professionals. The lack of information about these important professionals in the child's life is a violation of the October court order. I don't think we saw the papers from these specialists. It sounds like he needed parenting classes. Yes. Yes. We heard baby C crying in Justin's call to the PD. He has no clue. He's just vindictive. That was probably that and the microdots video where he's drunk was probably the hardest parts of all of this for me to see because, again, my grandson is 2 months younger. Yeah, I think 2 months younger than baby C. And my daughter is 5 years younger than Kelsey, but still, my daughter is a petite, blonde woman. And it just hit me because those noises, I hear those noises. I remember when he was little and you know the nursing sounds and give me attention sounds and I need comfort sounds. And I wanted to fly to Massachusetts and take that baby and show him that some men know how to raise a baby. What's ironic is I'm just an auntie and clearly knows more about babies than Justin does. You probably know more than a lot of fathers do. We call it keening sounds. Yeah, but you know there's the one noise that means I need a tit in my mouth because I need the comfort, and then I need a tit in my mouth because I'm hungry and I'm gonna scream till I'm blue in my head. One of them was very, very clear. And then you heard the frustration begin when Justin was drunk and yelled at her. Anyone who have had a baby knows those sounds, or should know those sounds if you spend any time with your child. Hernia surgery. This allegation is, again, a serious misrepresentation. The child was scheduled for surgery on July 2nd, but the parties needed to fast the child before surgery, which became intolerable for him, and the parties struggled with how to do that. Mother asked father to ride with her to the hospital for the surgery and help her in the car ride with a very upset, hungry, and herniated child. I remember I mentioned that as well. It's almost like I've had kids. He refused. Given the difficulties, she asked to reschedule very quickly. However, after the 209 was served on June 30th, father failed to take the child to this initial appointment and also failed to obtain a new appointment until 2 months later. And mother could do nothing to ensure it happened, as she could not only not communicate with the father or the child's providers, as she did not have legal custody, but she was also in the hospital fighting for her life. Mother's ability to care for the child and mother's mental health. Although father alleges, page 11 of his motion, that mother failed to respond to certain discovery requests, he fails to mention two very important details that negate this intentionally misleading representation. First, mother objected on the basis that her criminal trial was pending and she was not going to affect her defense, providing mental health records at that time, but would supplement the same. Second, on March 30th, mother, through counsel, in an effort to make that supplementation, provided a drafted confidential agreement. Oh, fuck's sake. Agreement to father seeking for this CNA to be signed, and then she would provide the mental health information that had been sought. Mother did not need to do this. In fact, she could have sought for this court to perform an in-camera review of the records before being willing to disclose her health records at all. But mother, in good faith, was trying to decrease litigation for these parties and get to the heart of the matter quickly. See ALM GLC 233, paragraph 20B. See also custody of minor, number 3, 16 Massachusetts, Appellant Court 998, 1983. Thank you so much, Bikrams, gifting memberships to Smarter Has Whole Lover. Oh, shit. Samantha Shoe Lover. I read that completely wrong. Mastermind 13. Jules Full Frontal Lobotomy. Michael's Cordil something. Horse and Laws, Digistorm, Dr. Russell's Gasp, Ali B, and Yuna Yansa. Thank you so much for gifting those wonderful people 10 memberships. And I am so sorry, Samantha Shoe Lover. You are not a hoe lover. That's more me. And the wonderful Restless Mom has been here for 15 months. That's more than a baby. Thank you so much. Always so nice to see you, even though you are an Anaheim duck. I think it is. No, Oregon duck. An Oregon duck. I don't know. They're probably as good as anything. I don't even know what game it is. I think was the pap smear when we read Justin's. Yeah. Almost 2 babies. Yeah. Before long, we're going to have grandbabies. I'm such an idiot. I say dumb things. To date, father has still not returned an edited draft of the CNA nor a signed version. Mother has no obligations to provide father with mental health records, absent some confidentiality agreement, in-camera review by this court, and other protections provided to her by law. Mother is more than willing to provide evidence of her mental health, but not without protections, especially given how this case has been subject to social media and other media that would risk opening these records to the public. Mother is not alleging that father would personally do that, but protection should be put in place, which mother has initiated, to which father is not responding. For father to now use his non-responsiveness against her is simply not acceptable. Thank you, Becca, for 6 months. Almost a baby. 2/3 of the way there. I have a lot of babies all of a sudden. Further, for father to opine on her mental health diagnosis is far from good faith, but done to cast a negative light on mother when she suffered from postpartum depression, a common situation in new mothers and something no court should hold against a mother in custody battle when those struggles are behind her. The statistic on postpartum depression in new mothers in the United States is between 10 and 20%, and is not a new phenomenon. It must be addressed, not punished. Mother has addressed it and overcome it. Phenomenon. Mother had a therapist, Emma Mandeville, through MGH, having heightened anxiety and depression from the pregnancy. Mother had seen this therapist since October 24. By March 25, mother knew she was not herself and was crying often. She voluntarily went to Lawrence General Hospital to be assessed in March 25, and she was diagnosed there with postpartum depression. Mother was released after approximately 12 hours there and followed up with her regular therapist. Notably, mother underwent a fitness for duty evaluation on May 21st. This evaluation was performed by Dr. Jill Durand, a licensed psychologist, who was asked to perform this evaluation by the NAPD after mother was diagnosed with postpartum at LGH and placed on a short leave. A report was issued on June 11th, just over 2 weeks before being served with the 209A. Dr. Durand cleared mother for returning to work, including use of a firearm without restrictions. Dr. Durand found that mother was fit to return to duty with no restrictions, and she reported that mother had no disciplinary issues or complaints filed against her and no issues of attendance on the job. Dr. Durand recommended that mother continue in therapy, which mother has done consistently. Mother then started to see Dr. Paul Seisel, a psychologist, in the summer of 25, who performed an evaluation and prepared a report on July 3rd relative to mother's mental health. He found that mother's actions on June 30th, after she was served with the restraining order, was to reasonable degree of psychological certainty, not a calculated act of malice, but a desperate reflective cry for help brought on by an overwhelming wave of hopelessness. He reported that on June 30th, he was met with an unimaginable confluence of stressors, experienced an acute transient psychological crisis. Dr. Seisel further reports that her actions that day are clinically consistent with a severe state of acute emotional dysregulation. One in chat if you think that you would have had a lot of stress and emotion if you had just lost your baby. I don't think that's an overreach to expect from a young mother. Dr. Seisel reports that mother's behavior was compelled by a state of profound grief and abandonment rather by a recent intent to harm herself. He found that at the time he performed his evaluation in the summer of 25, he posed no credible risk of harm to herself and that no clinical evidence suggests that she poses a physical or mental danger to the party's son. He assessed that to a reasonable degree of psychological certainty, the risk of harm from reunification is all but non-existent. He went on to assess that the continued separation of mother from her son is clinically detrimental and harmful to mother and child, and that the prolonged separation can disrupt and impede the child's development, growth, and capacity. I agree. Mother saw Dr. Seisel virtually while in custody in 25, then started to see him weekly from January 26 to March 26 after her release. Commencing earlier this month, mother has started to see him twice per month. So she went from weekly to bi-weekly. Okay. Mother has been seeing Dr. Khan since January 26 for medication regulations. She takes fluoxetine and lorazepam. Isn't lorazepam the one we always talks about? But it sounds like some antidepressants. Am I wrong? Yeah, not just her baby, also her job, her home, her fiance, and her dog. Yeah. It's Prozac and Xanax. Okay. I don't. Some form of that. But Xanax is that's a relaxer. Right? Ask for likes, please. Lol. Please like and subscribe. I'm very close to 24,000 subscribers. Lorazepam is anti-anxiety medicine. It's Ativan, a benzo for anxiety. Okay. One for depression, one for anxiety. Yeah, and I think she was already on the anxiety meds. Wasn't it her anxiety meds that Justin stole from her? Yeah. But she doesn't seem... We have seen her in court, which is a high-stress environment, but we also saw her on Aiden's show. To me, she seemed very calm, but not giddy or in any way under the influence of anything. I found her to be very level-headed and clear that what was going on around her. So it seems like she is in a very good state of medication. Okay. Thank you all so much. She was medicated, but she was not, because in Denmark we have had this because you cannot put people in a straitjacket anymore. That's inhuman. But then you just give them a medical straitjacket. You just pump them so full of medicine they're just sitting there drooling. So what's more humane? But I just said she seemed, because she was clear in her head. She wasn't under the influence. She didn't seem anyway like that. Oh, by the way, I made a QR code for Kelsey Fitzsimmons. Kelsey Fitzsimmons Legal Fund, if anyone wants to contribute. Mother recently met with a trauma specialist, Dr. Knopf, for intake. Her next full session is May 14th, who she will see every 2 weeks. Her current diagnosis is anxiety and depression. which is successfully regulated with medication, yoga, Pilates, exercise, and the support and guidance from her providers as detailed here. Who can fucking blame her? Mother has gone through a traumatic experience after suffering postpartum, and she is no longer diagnosed with postpartum. Mother has survived this ordeal from her own core strength and deep love for her son, which Dr. Seisel recognized in the mother. Letter from mother to father. Mother wrote the letter father cites in May 25 and left it on the counter for him to read after he finished work. He was present, he read it, hugged her, and cried. The fact that father alleges he just received it after the conclusion of the criminal trial is a complete falsehood. Father used mother's genuine affection and effort to be a better partner in the face of her postpartum against her. It is nothing more than heartless and disrespectful. And again, when I saw that letter, I thought it could also be because you have an abusive husband and you want to placate him, want to tell him, no, you're so wonderful, so he doesn't get mad, doesn't get angry. So that was one of those little things that it looks bad on paper, but of course you will try and write and say, oh, I have been an asshole. Yes, she's been fighting with depression. I have had depression. I was not there for my wife. I wasn't there for my children. I cried a lot. I lay inside with my blinders down because I had a massive depression. That's why I don't like to see when people share Aiden having his partner tantrum, because I can imagine what's running through his head. It's really, really hard when you have a depression. You just want to soldier on. You just want to do the best. And you will be an asshole sometimes because you have a depression. And maybe you're not met with the responses that you need. And then when you have a clear moment, you can see you are taxing everyone around you. You can see you are not a good mom. You are, have been unfair because you just want to be alone and cry. And then you might write a letter like that, and then you're throwing it back in her head and say, oh, look, you are a horrible girlfriend. I agree, Baker. And then we heard the video of Justin wasted and yelling at her. Who wouldn't be depressed? Especially if she already got depressed during the pregnancy. Then having a partner who doesn't. Again, men doesn't do a lot for babies the first couple of months. But we can change the diaper. We can do the night walking. We can burp them. We can give you some quiet. That's what our job is the first couple of months. It is to make sure that you feel comfortable, that you don't have to worry about, is there formula, is there diapers, is there enough food? That's our job. Your job is to make that little wonderful bowl of love just grow. But not every man sees that. And that's I have described this a lot of times, like I have a physical switch that was switched on the day that I became a father, and I know I'm no longer me. I am someone else's father. And when I saw my grandson the first time, when I seen my nieces and nephews, I get the same. I'm the guy who's always we were at a party in Rome, and my oldest nephew had just been born. I spent the entire night walking around with a baby because I really like babies. I'm a big guy, and they like to nestle into my titlets. Yeah, Robin, you and me both. Yeah, it's you can tell when they call. That call, yeah. I had an hour talk with my youngest daughter today. That was wonderful. Allegation of harm by mother to father and others. Now we get into how much of it is true. Now we had his version. Now we're going to have her version. Allegedly, she drove like hell. She kicked and hollered, was drunk all the time, puked in a shoe, or whatever else he alleged. Father's motion is inaccurate and misleading as to the North Carolina incident. In total, mother pled once to simple assault, not against any boyfriends, as father alleges. And after 100 hours of community service, it was expunged from her record for this very reason. So these minor incidents could not be used against her in the future to tarnish her name and reputation, to move past mistakes when she was 21 years old. Yet, father is doing this very thing over and over to mother. Despite this incident from her past, father still moved into her home, still had a baby with mother, and still asked her to marry him. Father knew mother was no threat to himself or their child. Yes, he raises this past expunged incidents 8 years later. It has no bearing on today's issue. Yes, I agree. Mother never attempted suicide in high school. These allegations come as an effort to smear mother, not to protect their child. The deposition of Michelle Mitchell is very telling, but not in the way father seeks to present. In the same deposition, which father fails to point out, is that Miss Mitchell admitted she had tackled mother on the steps of the home, bear-hugged her, and threw her into a wall. She also admits standing over mother when mother sat on the steps. We haven't seen the deposition of Miss Mitchell's. Standing over the mother when mother sat on the steps, which mother asserted was an intimidating stance after just having slammed her into a wall when mother tried to leave the property after everyone had been drinking and she wanted to leave. Mother did not punch anyone in the face, nor were there bruises or police report that Miss Mitchell's had. In fact, Miss Mitchell's admitted that everyone had been drinking at that party where Miss Mitchell's said this incident occurred, even herself. She also admitted that she did not know the reason mother wanted to leave, to which she admitted in her deposition. It is mother's position, essentially, that she had asked father to stop drinking and using drugs at the party, and when he refused, they argued. Mother then wanted to leave and started down the steps to just go home when Miss Mitchell's intervened to stop her for unknown reasons. Mother did not assault any former boyfriends, and mother has a good ongoing acquaintance with Mr. Minotti. In fact, father contacted Mr. Minotti on more than one occasion, and Mr. Minotti asked father to stop harassing him, and that he and Kelsey had a fine ongoing acquaintance and to stop searching for negative things about her. He would testify to the same if called to trial. So, Miss Mitchell's, who was the victim, the one who all of a sudden in her testimony to the police changed who she was supporting with her testimony. All of a sudden it was Kelsey who ran into the woods, and then she tried to drive her off the road. Apparently also had a deposition where she talked about a party where she apparently attacked Kelsey. Remember Miss Mitchell's from trial? One in chat if you think that Miss Mitchell's look kind of like she's going to look like Sandra Bullock, a.k.a. Carrie Roberts, in 20 years. I got the worst Carrie Roberts vibe off of her. She was just there because she wanted to hang with the cool kids. September 24. Mother asserts that she has never attended anything called a welcome party, but there was an event they attended together. Father got extremely drunk, clearly evidenced by father admitting that mother drove them home while pregnant. Most men would have driven their pregnant girlfriend, engaged later that month, to and from the event. Bradle, do you watch my show? I said all of these things. I would never have gotten so drunk that my pregnant wife had to drive me home. I said all of these things when I read his motion. You little sneaky. Is Courtney in here? I said all of these things were great points to point out. Wasn't much man in Justin. Unless he had been drinking, which is what happened here. Mother asserts that father was disrespectfully engaging with a woman at the event, and mother was upset. Father blamed his behavior on his intoxication and asked for mother's forgiveness. Just an alien, you fucking pussy. You can't even keep it in your pants while waiting for your son to come out. I know this will sound, and it's surprising because you must have some, because you had a kid. Let me tell you something, brother. Grow some balls. Grow up. Become a man. You had your pregnant wife with you at a party, and you decided to get so drunk that you started hitting on other women in front of your pregnant girlfriend. Sorry. If you want to sneak around, go find her bridesmaid and hit on her. You don't do it in front of her, you fucking idiot. And you don't do it at all. If you want to put the baby batter in the oven, you, sir, need to help with the cake. You didn't really like the responsibility, did you? You don't really like all the responsibility you have today. It's probably mom who told you to do it. What in all hell's? Kelsey, I don't know you. Bad boys are not the future. Cool guys with a little pedo stash. Don't do it. Find a boring, solid type. A guy who will get drunk twice a year. A guy who, oh, he's so weird. He sits and plays video games. Yeah, but he sits in your house playing video games. And when the kid cries, he gets up and takes care of that kid. Boring is way better. I know you're young and you believe that fantasy about, oh, the bad boy and I can tame him. No, you can't. Because he's a man-child. Man-child. So, Kelsey, listen to a 27-year-old virgin. We know a lot about love. Hoes and bad boys are for fun nights. Boring, dependable, smart people are for life. Write that one behind the ear. Father blamed his behavior on his intoxication and asked for mother's forgiveness. She did not drive over 110 miles. In fact, mother does not even have a speeding ticket on her record. Mother did not tell father to find another place to live, though she could have, since it was her home where they resided and were not even engaged at that point. However, father did ask for mother to marry him later that same month, clearly evidencing that mother did not act in the erratic and dangerous way he had described for the court. His credibility in the reporting of this incident is zero. Oh, Ashley. October 24. Father's sister Ashley had texted father, upset that mother was coming on the trip because she said it was a family-only trip. I fucking knew it. She's not part of the family. Baby C is part of the family because he's an alien. She's not an alien. Father confided to mother that they are engaged, having a baby, and that he did not understand why his sister was acting so hateful because she's not family. The parties did, in fact, go on this trip to Croatia, but mother admits that she was overstimulated, She overestimated what her body could handle while pregnant, as the trip consisted of hiking, long walks, long nights, and early mornings. Mother was at the point of her pregnancy where her lower back caused a lot of pain, later to find out the baby was pushing on her sciatic nerve in her lower back. Father's family vocalized to each other that she was being dramatic about the pain because 20 weeks isn't even that pregnant. One in chat, if you had bitch slapped anyone who told you at 20 weeks that you were not that pregnant. This caused her to no longer vocalize the pain she was in during the trip, but then quite presence caused his family to accuse her of being miserable and ungrateful. That's halfway, isn't it? Yeah, it's, I don't know. I was just there. I didn't count the days. But well, how would his unmarried siblings know, who doesn't even date? You're 2/3 of the way. Yeah, this is kind of where you normally start to really show. Well, depending on how big you get, but yeah, that's when most people start showing. Yeah, the Spincers is Ashley. Ashley is the one who looks like she does mattress actress, right? Just read your text. Do I have to yell at you, Jess? Get to it. She's also small, and how would they know? Again, my daughter didn't get big. She had probably had a smaller belly than I have now, but she wasn't that big. She was very small. Especially her mom got really, really big. Not fat, but had a big old belly. So I was surprised she wasn't bigger. I would say when she gave birth, she was 6 months pregnant, if it was compared to her mother's. During a particularly 6-mile hike, something mother would normally enjoy when not pregnant, she fell behind from the rest of the family. When she fell behind, father's brother Brendan would yell from ahead, "Hurry the fuck up." This happened on multiple excursions, when mother would fall behind and father would just shrug it off, or sometimes he would tell mother she needed to hurry up so his family did not get mad. Why couldn't she stay at home, put her feet up, and you could go out and be a family, because you didn't want her there anyway. She could watch some wonderful Croatian TV, drink some wonderful soft drinks, and she could have enjoyed her vacation, rested, because if she had rested instead of running around in Croatia is quite hilly and mountainy. Instead of running around for 6 miles while 20 weeks pregnant, she could have rested, and then she could have had energy for the night. Have you never had a baby? During this trip, the family had planned an off-roading excursion. The parties determined that it was too dangerous for mother being pregnant, so the parties stayed behind and rented bikes instead. His siblings were angry and felt that mother was holding their brother back from their family vacation and made that very known to mother, telling her she was a burden and should not have come on the trip. Justin, why didn't you say anything? Why didn't you say, stop it? For fuck's sake. During this 13-day trip, these situations made mother feel like she was on eggshells and a burden for being pregnant, and there were multiple times where she would cry and tell father how they made her feel. But it was not that mother wished she was not pregnant, nor said she wanted to end the pregnancy. Later that trip, mother was experiencing spotting from pregnancy due to the stress of that trip, and mother talked to father about the bleeding in the airport. She expressed how upset she would be if she had a miscarriage due to making the decision to go on that trip. Father immediately got upset with mother, questioning if she was blaming his family. He was immediately defensive and has now taken this narrative and twisted it for his gains in this case. As someone who have had experiences with people who has miscarriage, fuck all the way off. Especially with your first child, when you start having weird symptoms, you don't know what to do. Fuck all the way off. Justin, I just told you to be a man. Being a man means protecting your wife against your own horrible family. Yeah, he has no empathy. I don't think anyone in the alien family has that. Yeah, she was probably scared, and all he could do was make it about him. Yeah, and you will be scared. I remember when the first, I don't know what you call fake contractions, when she had them, I was scared shitless when she started complaining about it because it wasn't time. I was on the horn with my mom saying, "What are we doing?" I didn't say, "Could you just shut up? I'm watching the Super Bowl." My kid is from September, so that wouldn't make sense. But thankfully, all was okay with the baby. Her bleeding has nothing to do with mother ever punishing herself or harming her child, but rather the product of a stressful trip and father's family being insensitive and hateful. Upon returning from the trip that evening, mother made tea for the parties from a gift she brought father and which has arrived when they arrived home. They relaxed with their dog on the couch that night for a short period. Mother was shocked to read father's allegation in his papers. Mother was still very upset, though, and felt confused and distressed at how she was feeling during her pregnancy. She informed father she wanted to find treatment, and she later found that at Lawrence General Hospital. She talked with her OBGYN and her therapist at that time, and they discussed medication for her. But given her pregnancy, they had to be careful with what medication was prescribed. Father did not beg her to go to any facility, nor did he ask her to go to inpatient treatment. That was not necessary, as mother was probably taking care of her own mental health at that time. November 24. Mother asserts that this simply did not occur as described. This is now the second time father accuses mother of going 110 miles per hour, this time between North Andover and Boston, a heavy traffic and police surveillance area. Again, his credibility is zero with this narrative. December 24. Father did in fact attend a wedding at this time, and the parties did agree she should not attend given her pregnancy. An attempt to protect mother and child, not harm herself, as father's narrative consistently relay. Wasn't it No, that was in Mexico, that's right. During his trip, mother was in the hospital for severe abdominal pain during her pregnancy. When mother tried to reach father in Mexico, she could not reach him on his cell. He then tried the front desk of the hotel. The front desk reported that he was at a club and was not answering the phone in his room. Father admitted to going to the club and blocking mother's phone number. Kelsey, sweet Kelsey, listen to your mom and dad the next time you come home with a boyfriend. I bet you they said, "Are you sure, honey?" I know the first one is a dry run. You try them out and you find out, nah, and then you settle down with the next one. You go to Mexico with your highly pregnant wife at home, and you fucking block her number. What are you, 16 years old? It's okay if you don't want to talk to a girl, not to answer her. But when you put the baby batter in the oven and the cake starts rising, you fucking take some responsibility. Which is why she could not reach him via cell. Father never offered to take the next available flight home. Father did not stay on the phone with mother during the 40-minute drive home from Boston. March 25. Mother did have a breakdown on March 9th, and she immediately sought help. That is the same day she was diagnosed with postpartum. Diagnosed in Lawrence General Hospital. Mother agrees that she was on the kitchen floor crying. She went to the hospital voluntarily that night. There was no prolonged argument. Mother asserts that she never refused to let father leave. In fact, he never tried to leave. Father called her stepfather and mother for assistance. Mother never attempted to grab the baby and not let go. Mother's parents are available to testify to those events. That'll be a little meh. Mother was discharged about 12 hours after admission and was advised to follow up with a therapist and OB/GYN, which she did. Mother was very open and honest about the postpartum depression with father, which he is now using against her in this case. Mother was placed on leave around this time, but later had an evaluation for her fitness for duty performed by Dr. Jill Durant of PCS for the NAPD. This evaluation was reported on June 11th. Mother was cleared to return for work without restrictions. Her return date was scheduled for less than 1 month later, July 25. May 25. The parties were having dinner with friends and mother did get upset that evening. David, father's friend, was not simply reminiscing, but talking about father and his ex-girlfriends and things of a sexual nature. Imagine a dickhole has dickhole for friends. Mother informed them that such conversation was inappropriate. Not only did it make her feel understandably uncomfortable, but their child was next to them. Father later apologized, but none of the erratic behavior he described occurred. Do we need a one in chat if you would have been upset if your husband's body was sitting there and saying, oh, you remember Sally? As we called her, Thumbbutt Sally? She was a fun one, right? Oh my God, the STDs that woman had, but luckily you didn't catch one of them. You keep the boys' talk to the boys' room. You can do all the dirty talk and reminiscence about whose boobs were the biggest in high school. You're at a nice dinner with your kid, presenting your kid to your friend. You don't talk about, oh, fisting Felicia. It took quite a job to make her feel something. What the hell is wrong with these people? Yeah, Thumbbutt Sally, she's well known in North Andover. She liked to have the bowling ball stuffed. I can draw a picture. With respect to their son rolling off the bed, mother admits that this occurred, but to convey this to the court as though mother cannot care for the child is disturbing. Mother had already woken up at 6:30 a.m. that morning to feed their son, and father was at work. Clearly, he knew she could care for their son and left mother and son at home together without pause. Mother and child's routine at that point was to wake up early, feed him, and then allow him to go back to sleep in the party's bed until approximately 10 a.m., with mother laying by him. Mother would place pillows around the baby. However, their son had somehow rolled over all the pillows at 3 months old, and he fell off the bed onto a pillow. Mother called father immediately, and they kept a close eye on him for good 24 hours to make sure all was okay with him. They were under the impression he never hit his head and any part of his body because he fell off the bed onto a pillow. As such, the parties did not seek medical treatment. Their son showed no signs of injury and pain. Accidents happen. My daughter's son, my grandson, fell out of bed when he visited me the first time. And he was 8 months at that point. He screamed like shit. We kept an eye on him. We didn't seek medical treatment because he seemed fine when he stopped crying. June 25. Father did in fact attend a mercy meal for one of his co-workers. He was supposed to arrive home at 7 p.m., but he did not arrive until 9 p.m., completely intoxicated. Mother was visibly upset about it and tried to express her concern about his drinking. He was also worried about him driving while having been drinking. Nevertheless, she had ordered dinner for him for a 7 p.m. arrival, and he did not arrive at home until 9. Mother was upset, and she left the house for about 15 minutes and went for a drive to have some distance from the situation. Had father been so concerned of mother acting erratically and afraid for the baby's safety and mother's safety, he would have called the police to check on mother and child driving away, but he did not do so. And now we come to the big one. The Jack and Jill party. This is a big thing because there are witnesses to this. All of the rest of it has been he said, she say, or I can get my mother to testify, or I can get my family to testify, which will be a little dubious how truthful they will be. "20 weeks, I was still very tired." Yeah, of course you were. "Isn't falling off the bed a rite of passage?" I have multiple scars in my head because I am famous in my family for making holes in my head or being thrown downstairs by my siblings. And I'm not that weird. With respect to the Jack and Jill party, the parties attended, mother has video of that evening where she had been drinking, but not acting negatively or erratically. Miss Mitchell testified that everyone there was drinking, not simply mother. In fact, it was mother who asked father to stop drinking and smoking weed and to come to bed, which is why she asked him to come upstairs to the bedroom. However, father refused and continued partying. Miss Mitchell did not know who pulled anyone's hair. On page 46 through 49 of a deposition at Exhibit C of father's paper, Miss Mitchell admits that the way she was bear-hugging mother on the steps when mother was one step below her, that she did not know how, if at all, mother could reach around behind her to someone standing on the steps above or below them and reach their hair. Miss Mitchell had no idea who pulled someone's hair and did not actually witness it. Yet father alleges mother pulls someone's hair, completely taken out of context and untrue. Miss Mitchells also admit that mother kicked her in the knee only after Miss Mitchells had already assaulted her on the steps. Mother's reaction was in self-defense to keep Miss Mitchell away from her. She had a really funny demeanor in court. Now we know why. Mother then walked out of the home. The home was surrounded by woods with a hiking path. The woods were only about 10 feet from the door where mother exited. These facts were admitted by Miss Mitchells in the record. Yet, father tries to paint the picture of mother acting crazy and walking into woods. In fact, mother wanted to remove herself from the situation and walk down a hiking path. While father cites Miss Mitchell's testimony as saying her reaction was just not normal, Miss Mitchell later admitted that because she did not know what occurred between the parties nor heard what was said, then she can't define what's normal and not normal. The most concerning part of father's allegation is the way he twisted mother's message to him. For instance, he alleged mother said she was going far, far away, but father's own testimony at mother's recent trial in March revealed that she said to a land far, far away, and he knew that meant her father's property in New Hampshire, which father knew very well. In fact, he proposed to mother there. He also knew mother's father called that place a land far, far away. And her father had a little song when mother was little that they would sing about the property to get the kids excited to go. Father twisted that phrase when trying to spin the narrative against mother. In fact, father knew mother was not a danger to the child. Their text messages reveal it all as follows. June 29th. Father explains he will go to mother's home where they had resided until father chose to end their relationship, unbeknownst to mother until that day. He said he needed to retrieve some belongings. In the myriad of messages between them that day, mother not only asked father to come home and to work on whatever it was that was straining their relationship, but she also messaged the father asking if he will be with their son on June 30th so she can do CPR training at work. Father texts the following. I will not be guilted or manipulated into this, meaning coming to the house. Baby C should absolutely be okay. There should be nothing wrong with him, is there? I will pick him up if you need or want me to happily. Otherwise, I'm not coming over today. What he needs is safety and calmness. That is all he needs right now. I'm not coming over today. Give me space and stop, please. When she asked him again to come see her and the baby and get his truck, his response is, no, I will get it at some point tomorrow. I need space. Leave me be, please. Later the same night, after 8 p.m., he does in fact go to the home and retrieve belongings. He did not take the child, nor did he have police do any wellness check. Mother and child were fine. Mother, sensing something was odd, told him he was calling her mother to come to the home, and when she arrived, they could come in together. Father reports that he had asked mother to call her mother, but that was mother's idea. At no time was father truly concerned about their son. He refused several times to pick up the baby unless mother needed him to do so or wanted him to do so, which he clearly wrote in a text. If he was concerned, he would have gone there and taken the child at her request to come home. June 30th, father still did not pick up the child or go to the residence. Mother had to take the child to a CPR training at work. Meanwhile, and to which Miss Mitchell testified, father was up the street at his buddy's house with other individuals, plotting how to get a restraining order against mother. Miss Mitchell couches it like they were concerned for mother, then the child, but when questioned on it, they never even inquired where the child was, and she could not or would not tell counsel what plan they actually had. Notably, the child was at CPR training with mother, safe and sound at NAPD training. Here's the relevant excerpt starting at page 83, line 6. So how did this group of you on the 30th decide to meet up to discuss Kelsey? Katrina called me and we just made a plan to go to his house. You and Katrina. Sorry. Yes, we made a plan to meet at Hunter's house. What was the plan? To keep Kelsey safe. What was the plan? That's an objective. What was the plan? We were trying to meet up with her to get her some mental health help. By doing what? To get her help. By doing what? We don't know. You didn't even come up with a plan. You just sat around and talked about it. We talked about how to keep her and the baby safe. We had thought she was suicidal and our plan was to meet up with her and go from there. To meet up with her where? Wherever she would meet with us. She wouldn't meet with us. Who tried to meet up with her? I did. Okay, by doing what? I asked her to meet me to go get coffee and she declined. She was, well, that was the 30th, right? Yes. And didn't you learn that she was supposed to be doing some kind of training? It was either the 29th or the 30th at work. The 30th. I was in touch with the Lieutenant Whitaker from North Andover, and that's when he told me that she was there doing in-service CPR training. So not only did the North Andover police fuck up the serving of the restraining order, they also actively knew about these plans being made. So when Lieutenant Whitaker saw her at the police station that day, he already knew that they were planning to do this. Why didn't they do anything? If they are so concerned she's in contact with Lieutenant Whitaker, why didn't they stop her? Why didn't they take the baby? Why didn't they do nothing? So even though she was at work with colleagues doing training to save life, you still thought she was suicidal? Yes. Okay. And how long was she in the CPR class or training? I don't know. So you don't know the hours that she was there? No. Okay. So what was the plan that you guys came up with at Hunter's house to help her? We were trying to just get her. There was no exact plan set in stone. Okay. What were the ideas that were thrown around? I don't know. I don't recall. What do you mean you don't know? You were there, right? Yes. Okay, so what were the ideas that were thrown around to get her some help? I don't recall ideas being thrown around, but she just needed some mental help. Were you all drinking that day? We were not drinking that day. At least I was not. Was anyone else? I can't speak for anyone else. Well, you witnessed them there at Hunter's house, right? I can't tell you if they were drinking at all that day. In Hunter's house, did you see anyone drinking that day? No. Are you sure about that? Yes. And I'm sorry, you might have said this earlier. Was Justin there too? He was. Okay. At Hunter's house, yes, with Courtney. Of course, he can't go anywhere without his sisters. And that's up the street from where the North Andover home of Kelsey was, correct? Correct. How far up the street? I'm not sure. Within a 5-minute drive. Drive, not a walk. Correct. Yep. Okay. 5-minute drive. And I'm not familiar with this area. Is it on the same street? I don't recall. I know it's close by. Okay. You don't remember any of the ideas that people threw around to try and help this woman. I know Justin was trying to make sure the baby was safe, and then he ended up going to the courthouse to file for a temporary restraining order and temporary custody. Well, if she was at training, where's the baby? I do not recall. I don't know. Mom's in CPR training, Justin's at Hunter, and no one knows where this kid is. You have to ask them. It's not my baby. And you were going to be her bridesmaid. Have you felt a little alien inside of you? You guys were meeting to figure out how to keep Kelsey and the baby safe, right? Correct. Nobody thought to think where the child is right now. Somebody was probably watching the baby. Nobody found out. I do not know. I don't recall where the baby was. How long were you at Hunter's house? Several hours. Okay. Between what times do you recall? 2 p.m. up until maybe 5:30. And one of these ideas that was thrown around was to get a 209A, correct? I don't recall. One of these ideas that was thrown around was to get a restraining order against Kelsey, correct? Correct. And one of the ideas was to use that restraining order to take the child, correct? Correct. And were any of the ideas to call her doctor? I don't have a doctor's number. Maybe Justin has her doctor's number? Justin has been with Kelsey for how long before this meeting on the 30th? How many years? I don't know. Within a year, 2 years. Okay. So did you ask Justin if he knew who her doctor was? No. Nobody threw out the idea, let's talk to one of her doctors and talk about if they can call her and check on her mental health. No. Kelsey, far from me to tell you anything about friendship, good friends, bad friends. But let me just suggest, whatever connections you are out there making right now, make sure one of them is not with Miss Mitchell's, because, oh my God, what a piece of shit. She was there to help Kelsey. No, you weren't. You didn't know shit about what she was doing. You were there to hang out. Oh, yes. And if anyone is interested in maybe supporting Kelsey a little more directly, she has a Substack where she's posting poems she wrote while in jail. I don't know if I have any mods here, but maybe if one of you can find the Substack link, that would be appreciated. These people are poop noodles. This is just unfucking believable. Yeah. Again, this is her testimony. This isn't just something Kelsey says, because the Jack and Jill party, we don't really go into that much. I had hoped we had more from it. But it's more the The rest of it, when she's just sitting there, I don't give a shit. I just want to hang out with them. Half the mods are drunk in Ireland. Yeah. Good thing we have Jemima here. This is the link to the Substack if anyone wants to go and read some of the poems she wrote while in prison. Help her out. She is out of a job. She has a new home. And hopefully she will soon have to have some extra expenses for the baby. Then between these 2 days of June 29 and 30th, father and his sister had called the police asking how to keep mother from going to New Hampshire, which again proves he knew mother was going to the New Hampshire property, not some crazy land far, far away. He knew where mother meant that she would be going with their son, a family vacation property in New Hampshire. He even admitted on the recorded line that mother is telling me she's planning to take the baby up to New Hampshire. The police on a recorded line let him know that he really have no rights, especially to take the child from the mother and prevent her from going across state lines. The lieutenant said they don't have the right to deny her child. Father asked, "Do I have any rights? It's my turn to have the kid for the night." The lieutenant said, "No. Through the police department, we don't have that ability." Father and his sister asked what they could do to prevent her from going to New Hampshire. At no time, while speaking to a lieutenant, did father say he was afraid for mother or child or father's well-being. The sister then piped in and said, "We need to get the baby out of her hands," and asked if it makes a difference that she was trying to take the baby out of state. The lieutenant responded, "It really doesn't. It's her child." She said, "If we file this, it will end horribly. Would a police officer come with us to get the baby if custody was ordered after filing for a restraining order?" The lieutenant then explained that if that was filed and he was granted custody, then they would take the child. Father filed for a 209A late on June 30th, 2025, which was issued based on his affidavit. His affidavit, however, was repleted with hearsay and witness statements that have, in this opposition alone, been clearly refuted after questioning under oath. Further, he used that far, far away language against her, even though he knew and admitted to the police on June 30th audio that she was just taking the child to New Hampshire, a family vacation property. He twisted it to sound crazy and scary. He failed to report to the court that the mother had invited him back home on June 29th and 30th, asked him to be with the child the immediately prior 2 days, and he refused to go there or take their child, actually arriving the night of June 29, taking belongings and leaving the child. He told the police on June 30th audio that he just wanted his night with the child, not that he felt the child was unsafe in any way. He could have taken the child when mother asked him to help her when she had CPR training, but he did not choose to do that. Rather, he chose a restraining order with complete misrepresentations and half-truth. Father argues in his motion that mother frantically kept driving by Hunter's house. However, if he felt she was doing that with the baby, would a father not try to stop her and or call the police to get the baby? The fact is that father knew she was not doing that. In fact, he knew mother had CPR training that day, and also he had told mother he would meet her at the park that day, which he never did. Mother had to drive past Hunter's home to get to and from these areas. Mother did notice father's truck at Hunter's and wondered why it was there when he told her he had no gas money to get there to take their son when she had CPR training. Father admits in his motion that it was only after he had been hanging out with his friends for hours that he decided to apply for a restraining order. This was not a decision based on fear, but rather a narrative created just to allow father the rights he was upset he did not have when it came to decision-making for the child, which he had just discovered that day on the phone with the NAPD. Allegations of fits of rage. Mother denies these allegations outright. They are also not credible. Father had no photos, police reports, or other evidence that these incidents ever occurred. Even so, they are between 1 to 2 years ago and do not evidence the current situation. Some alleged incidents were when the parties had a child together And yet he still chose to co-parent with her and ask for her hand in marriage. Father's narrative is not credible. His narratives over and over involve times when they are in a car together, yet he continued to ride with her, ask her to drive him when he was intoxicated and she was pregnant, and also drive her places. He never stopped being in a car with her, despite her behavior, as he describes it, to be scaring and appalling. On the other hand, mother has video of father intoxicated, falling over in the home, and unable to function. Mother has videos from the security cameras in the home where he is smoking marijuana constantly. He has even been put on administrative leave from the fire department for his failure to abstain from drugs and alcohol. Mother was never in such a position with her work, who actually cleared her to return to work after a postpartum episode. Yet father fails to account for his own drug habits and alcohol consumption, trying to ruin mother's reputation and abilities to see her only child with his allegations. Mother has already submitted to a 12-panel hair follicle test, which came back clean. It is available to the court this hearing. Summary. Father alleged that he believed it is important for mother to be reunited with their son. However, despite the 209 provisions being vacated on April 14th, all but the non-abuse provision against father, notably not involving the child in any way, father refused to allow mother to see their baby from April 14th to April 24th, even supervised. Father offered mother a visit between mother and child on April 25th at his attorney's office, supervised by counsel. While mother was ecstatic, it was completely dictated by father, and he knew mother had to agree or not see her child. He jumped at the chance. That visit went very well. I'm glad to hear that. Father is also seeking for mother to only have 42 total hours, which is less than 2 full days, with their child over a period of 2 months. Nothing in his allegations, considering the lack of credibility in the same, warrants such limitations, nor does it provide any way for mother to truly reunite with their child. The proposal mother has made actually does that. Mother's proposal, taking into account any doubts this court may have about mother's safety with the child or any level, allows for mother weekly supervised visits on Sundays for 5 hours with a supervisor to occur at mother's current residence 3 times. The supervisor would provide a summary of the parenting time, how the child presents with mother, and raise any concerns via written report provided to counsel of the parties. Mother's proposal, given time is of the essence as this baby is growing each day and mother is losing quality time to watch him grow, then expands to the supervisors being the maternal grandmother and or stepfather and occur at mother's residence for 3 days per week and 5 hours each day for 2 months. The maternal grandparents, who the Superior Court has previously vetted for mother's release from custody, would report to all counsel of the parties with a summary of the parenting time, how the child presented with mother, and raised any concerns. Therefore, the parties would follow the traditional 2-2-3 shared parenting schedule, with mother having Mondays and Tuesdays, father having Wednesdays and Thursdays, and the parties sharing the weekends, Friday, Sunday, alternately. See mother's proposed order. This proposal gives gradually increasing time with the baby, despite mother not believing it is necessary at this juncture, as her mental health is good, she is in therapy, and by all reports she is doing well. Mother recognizes, however, that the standard for this court to make a decision is the best interest of the child, and given all the allegation, this court must consider all factors to make a well-rounded decision on a temporary basis. Mother believes that her proposal takes into account all of the issues presented to this court. Further, the fact that father seeks for this supervised and limited time to be done at the same center where he has been using the so-called specialist for assistance in parenting his own child means this particular center has heard all of father's narratives and allegations and has likely completely biased this center against mother, even if unintentionally. This would be the same center who has already allegedly written that father is this child's favorite person. To presume that this particular center would be neutral in any type of supervision is beyond comprehension. There is no need for a 60-day supervision of nothing more than 42 hours in total, where nothing positive or natural can happen between mother and the child. Mother's proposal, on the other hand, allows for a stepped-up parenting reunification in a natural environment, supervised initially and gradually stepped into a more normalized plan. Father can point to no evidence that suggests the type of supervision he is seeking is the best for their son, or that it's warranted at all. Because mother suffered from postpartum depression a year ago does not mean she should be ostracized in this fashion from her only child, especially when she is willing to provide her mental health records to the court and to father with the appropriate protections. What father is seeking is punishment, not co-parenting. While father is seeking a guardian ad litem, it is known that a GLA will not complete any assessment in less than 2 months, and even then, a hearing would need to be had to implement any recommendation, which father could easily delayed. That doesn't make sense. Which father could easily delay by simply saying he needs time to cross-examine the GLA in a deposition or at an evidentiary hearing, which would further delay mother's access to the child in any substantial way. Effectively, seeking a GLA is only putting distance and more delay of the mother-child reunification. While mother admits she had postpartum depression, diagnosed in March 25, and some behavior at times was due to that mental health issue at that time, father's narratives are not credible, and he seeks to capitalize on mother's short period of postpartum to create some ongoing mental health problem where mother is a danger to their child. However, father's own behavior disrupts those narratives when he had opportunities to retrieve the child from mother, and he chose not to do so, evidently refusing to go to the home and pick up the child because he needed space, unless she really wanted him to do so, per his message to her on June 29th. When he retrieved belongings from the home but not the child, when he left the baby with mother when she was home from maternity leave, and he was gone all day. The child was always safe, and he knew that. His alleged fear of her and for their child is not credible. Mother is not a danger. She has had the mental health support from the therapist and psychologist. She has had the fitness for duty evaluation performed in June 25, which cleared her for work without restrictions. She has passed a full panel hair follicle test in April 26. She remains in ongoing therapy and was acquitted of the charges brought against her. Wherefore, mother respectfully requests that this court deny father's verified motion. Julie R. Hess, Esquire. I feel this is a well-written motion. I feel it's very poignant in pointing out all of these issues where it hits. It's kind of like the restraining order that he filed that was clearly made so it would hit what you need to hit. This one is also saying all the buzzwords. It's clearly pointing out she's willing to cooperate. She's willing to do what's best for the child. She doesn't come off as she just wants to rip the baby out of his hands. She want to go 2-2-3. And I can tell you in Denmark, the normal shared time would be one night at the other parents per year. So in Denmark, she would have 1 night. So this 2-2-3 is more than you would have here. But I think it's appropriate. He's almost a year and a half old. And she needs her baby back, and her baby needs her back. Like I said yesterday on Masas, our wish for revenge on Justin or to harm Justin has nothing to do with baby C. Baby C needs the best solution for baby C. With what I have seen in papers, and of course this is written by partisan hacks, I don't see Justin as a great dad, as a man who is capable and willing to take care of a baby. He can be the best dad. He's just not on paper. But I wish I had Exhibit A, which was Miss Mitchell's paper, because I have this suspicion that a lot of all of this bullshit stems from the family and women who wanted Justin. Kind of like with in the Karen Reed case, I think a lot of the reasons why it ended where it ended was there were some women who was really mad that John O'Keefe had found himself another woman than them. So, yeah. I think that's why we need someone close to. I bet you Miss Mitchell has already offered off services to Justin. If he didn't even try some of those services before. Based on the way she acted in court, based on the way she presented herself, I could be convinced to think that by the way, I'm being sued allegedly. I've been told on Twitter today. But I could see a scenario where Miss Mitchell thought, oh, get that anky little blonde out of here so I can take up his whole life. I could make such a great wife for him. Mitchell the Bitchell. So thankfully she can finally respond, because his narrative had been out in public since June 30th. Exactly. And we will have to see what happens tomorrow. I haven't heard anything about law girls, not attorneys, going to court. I haven't heard anything about Justice Serve TV if they're going to court. If they do, if they offer it up for us to use, I will do it. But other than that, of course, if I see it out there, I will potentially show it later. But I will. I don't stream snipe while live. I want them to have the clicks and the views because they're doing the work. But if they offer it up, if they're going, of course, I will most likely cover it. As I stated earlier today, my life is like this right now, so I hope I can cover it. And yeah, we need to keep an eye on this. When they sue you, please ask about John Socks. But I don't know who is going to sue me. I was just that Mike Drury told me that watch out, though, boy, you're getting sued. I don't know what I'm being sued for, because I have never stated who killed John O'Keefe, just that Karen didn't do it. So, I don't know. Michael is he streaming it tomorrow? Okay. Justin doubles in a new motion just posted on Mass. Jemima, can you see if you can find that? Life is always a roller coaster. It goes up and down sometimes, and then it goes straight again, and then gracias. Ms. Mitchell stated in a testimony or affidavit somewhere that when Alien left the Jack and Jill, he stayed at a hotel with a friend. Mitchell also stayed at a hotel that night. No, she drove home and was almost driven off the road by Kelsey, even though she drove half an hour before she left, because that's how cars work. Yeah, the good mod can do anything. Just hanging out for that because it is 11:06. So I kind of hope that there's not another 30 pages I have to read. It's been a long day reading stuff. But hey, if you're not first, you're last. And I want to know it because I'm getting angry about all of this. The worst part is I don't give a shit about Kelsey and Justin and their relationship. What I'm mad about is a baby is being used as a tool. Again, there's no shame in saying this doesn't work. We're going to be worse for the kid together than we are separately. I walked out when my kid was 3 months old. The kid I just had an hour conversation with today. We have a great relationship. It's been better the older she's gotten. Because had we stayed together, we had ruined our kids. I'm 100% sure of that. Well, you can keep Rumble in check. Except you didn't delete the comment I asked you to earlier because it's Monday. It's 20 pages long. Beep, 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 beep. Meh. Beep, 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 beep. Meh. Let's do this. I just need 2-minute mind break. I'm going to play what do I have that's a couple of minutes? I just need to just not look at myself for a second. Don't leave. I'm just playing this to fill up some time when I'm just do the intro song so people don't think we're going out.
Jamie is the boss, running the show. Marissa is the mod, we have nice mods too. Jamima gets the docs, don't you know? They're the ones yelling at Baker all day. Yelling at Baker all day. Hey, hey, hey. Yelling at Baker all day. Hey, hey, hey. Yelling at Baker all day. Hey, hey, hey. Making sure he hears what they say.
Let's do it. Oh, I forgot to share the site. I was ready to go to bed. Yes, sirs. Thank you so much, Jemima, for finding it so fast. That was the wrong page that I just put full screen. That's not what I want to do. You go back. This is filed today at 3:50 p.m. Justin Alien versus Kelsey Fitzsimmons. Thank you, bless Texas Lolly, for 6 months. Baker, you're the best. Appreciate all you do. Well, I'm apparently not that smart. That should just have run out of here before anyone had told me. So, yeah. Yeah, Melanie started about an hour ago. I could see my numbers just dumping fast. Fantastical. Thank you for 1 month. You're a legend. Thank you for your time. No, it's fine. It's fine. It's fine. So go out and get the 600 people who left back and tell them to like and subscribe and get me to 24,000 subscribers so I can. I don't know what I'm going to use it for. I am already the second most live viewed Danish streamer. So, except when they played some stupid video games, but they're based out of Pakistan. Just calls themselves Danish. Father's verified opposition to mother's motion for further temporary orders. Now comes the alien through counsel, and he requests the Honorable Court deny mother's motion for further temporary orders. In support hereof, incorporates by reference plaintiff's verified motion for temporary orders. Brief background and procedural history. Incorporates by reference the brief background and procedural history contained in plaintiff's verified motion for temporary orders on April 3rd and further states as follows. On or about April 3rd, father filed plaintiff's verified motion for appointment of Category E guardian ad litem and plaintiff's verified motion for further temporary orders. A hearing on father's motion was initially scheduled for April 23rd before Judge Black. On or about April 9th, and ahead of the review hearing scheduled for April 14th, on the instant 209C matter, the parties filed a joint review memorandum of the parties. On or about April 14th, at the 10-day review hearing on father's 209 abuse prevention order, the parties filed a stipulation of the parties to extend and modify 209A abuse prevention order, which was allowed by the court, Judge Black, that same day, and states in pertinent parts as follows. The parties agreed to extend and modify the 209 abuse prevention order as follows. Paragraph 2, 3, 4A, 6, and 7 shall be deleted. All other provisions of the order shall remain in full force and effect. The parties agree that the 209A abuse prevention order, as modified herein, shall remain in full force and effect for a finite period of 90 days. The parties has entered into this stipulation with the benefit of advice of counsel and has voluntarily executed the same. The parties agree and stipulation that there has been no 10-day hearing within both parties testify and challenge the allegation made by the other in this matter. The parties acknowledge that the plaintiff maintains the alleged fact reference in his complaint and supporting affidavits. The parties further acknowledge that the defendant does not, by entering into this stipulation, admit to, acknowledge, or agree with the plaintiff's allegation of abuse as referenced in his complaint and supporting affidavit. The parties entered into this modification and extension agreement without prejudice. The parties request that this honorable court extend and modify the 209A order as referenced herein. Notably, paragraph 1, the non-abuse provision, and paragraph 12, the provision requiring mother to surrender all firearms to the North Andover Police Department, suspending mother's license to carry and fit card, and prohibiting mother from possessing and or purchasing firearms and ammunition is still in effect, which has no bearing on anything. On or about April 14th, the court, Judge Black, modified and extended the 209A abuse and prevention order in accordance with the stipulation of the parties accepted by the court attached herethrough and incorporated by reference herein. A review hearing on the 209 abuse prevention order is scheduled for July 13th at 10 a.m. in Lawrence before Judge Olvig. On or about April 14th, the parties filed a joint motion to move hearing date from April 23rd to April 28th. The court allowed the joint motion that same day and ordered that mother's motion for further temporary orders, plaintiff's verified motion for appointment of Category E guardian ad litem, and plaintiff's verified motion for further temporary orders be heard at 10 a.m. on April 28 in Lawrence before Judge Ulrich. According to the online docket, it appears that Judge Mitchell Monevar will be hearing these motions. There is a pre-trial conference scheduled before Judge Ulrich on July 15th. In issuing any temporary or permanent custody orders, the probate and family court shall consider evidence of past and present abuse towards a parent or child as a factor contrary to the best interest of the child, MGL C209C 10. Where there is a finding of a pattern or serious incidents of abuse, the judge must employ a rebuttable presumption that sole or shared custody with the abusive parent is not in the child's best interest. Rector vis rector. While there is no definitive checklist of factors to determine the best interest of the child, we consider certain constants such as which parent has been the primary caretaker and formed the strongest bond with the child, the need for stability and continuity in the child's life, the decision-making capabilities of each parent to address the child's needs, and the living arrangements and lifestyle of each parent and how such circumstances may affect the child. Chavi Chabab. For joint custody, a shared responsibility to work, both parents must be able to mutually agree on basic issues in child rearing and want to cooperate in making decisions for their children. Marcy v. Marcy. Massachusetts General Law, Chapter 208, 31 governs the custody of children in Massachusetts, which defines shared legal custody as the continued mutual responsibility and involvement by both parties in major decisions regarding the child's welfare, including matters of education, medical care, and emotional, moral, and religious development. Joint legal custody requires parents to have a willingness and ability to work together to reach results on major decisions in a manner similar to the way married couples make decisions. Mason v. Coleman. Joint legal custody is synonymous with joint decision-making and a common desire to promote the children's best interest. Roldy v. Roldy. Father's primary concern is the 14-month-old child's emotional and physical safety and well-being. You just removed the restraining order that had anything to do with your child. So you hate for the child to have anything, but the only rules that you had in the 209 that is still existing is she's not allowed to attack the dad and she can't have weapons. You removed anything with the child. Due to his age, the child is unable to speak for himself and unable to report his own observation during visitation. It should be noted that each and every court order in this case, as well as in the 209 case, has been the product of an agreement of the parties and counsel. Father supports mother's relationship with the child as long as it is safe and healthy. Father has little to no information regarding the status of mother's present mental health and treatment. Father's counsel does have a report dated July 31st from Dr. Paul D. Seisel, Psych D., who was mother's expert witness for the criminal matter. Mother spent approximately 2.5 hours with the child and father on Saturday, April 25th, in the presence of counsel at a visit suggested and facilitated by father so that mother did not need to wait to see the child. There was no reason to wait to see the child. You agreed to let her see him. You lifted all the provisions. There was nothing preventing her from seeing the child other than you, just an alien. I'm not sure he has the best counsel. I'm just not sure. Father's sole motivation is to ensure the emotional and physical health and safety of the child and to protect the child from public attention. Well, you fucked that up royally, didn't you? You made your baby known around the world. Pursuant to several court orders, the father has had legal and physical custody of the child since June 30th, nearly 10 months. The child was 4 months old when the father was granted legal and physical custody of him. Why? The child is healthy, thriving, well cared for, and is meeting all of his developmental milestones. Father has kept mother timely appraised as to the child's development with monthly updates, which also included photos and videos of the child. Didn't she say that they didn't do that? Well, again, that's a he said, she said. On or about June 30th, father was granted legal and physical custody of the child pursuant to the 209 abuse prevention order he obtained against mother. On or about October 21st, the parties agreed pursuant to the stipulation for temporary order on plaintiff's verified motion for temporary orders dated October 21st, which was incorporated into a temporary order dated October 28th, that the father would continue to have legal and physical custody of the child and that the mother would have no parenting time. Why? 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 You forget the reason why she agreed to that. Her fellow officer sent her to prison by shooting her in the chest because you, Mr. Dickweedle, sent the police out there. Hopefully you bring that up later. Since obtaining legal and physical custody of the child nearly 10 months ago, the father has been the child's primary caregiver. Father is responsible for baby C's day-to-day caring, including but not limited to feeding him, clothing him, bathing him, putting him to bed, playing with him, reading to him, scheduling and transporting him to his medical and surgical appointments, scheduling his early intervention visits, etc. As is detailed in the plaintiff's verified motion for further temporary orders, according to the child's pediatrician and early intervention specialist, the child is thriving, making great progress, growing, is very well cared for, is healthy and happy, and is meeting all milestones and has a close attachment to the father. According to the child's EI development specialist, notes that dad continues to be the minor child's favorite person. The child is securely attached to father, and the child is cautious around new people and unfamiliar situations, preferring to be held only by father when he feels unsure. Like every other 15-year-old baby who doesn't live with their mother because their father got her sent to prison. At the recommendation of the child's early intervention development specialist, father is also consulting with a social worker on a regular basis relative to parenting and support, as well as the child nutritionist to help support the child in learning how to self-feed. I was 24 years old when I had my child. None of my siblings had younger children. My wife was 23 years old when we had our first child. We had both just been deployed. I came home about a month before I had my first baby. I didn't know shit about babies. She sent me a lot of books and I threw them out because everyone was about how mom and baby is going to die during the pregnancy, during the childbirth, or getting a meteor in their head. You know what, Justin? Bro, homie, I didn't have to have a social worker come out. The only help we had with feeding her was I learned that trick you do with the nipple to get them to latch onto it, because sometimes she wouldn't latch, and it's easier if the dad uses the fingers. And one in chat, if you have stood there and squeezed your wife's nipple so the baby could latch onto it. You know what we also did? Because she had colic and she would throw up the breast milk and my wife would run dry. I walked around with a bottle and bottle fed her so she could have some food in her stomach. No one taught me that. I bought a bottle. I bought some formula. I read the description. I heated the water. I made sure it wasn't too hot. And then I bottle fed my baby so my wife could have some quiet time and replenish, make new milk. Then when my kid got older and she started eating solid foods, I didn't have anyone come out to me and say, hey, you're holding the spoon wrong. No, we started just spoon feeding her. And when she got older, you just cut the pieces of food out in small bite sizes and let them sit there and put it in their mouth. It's a messy, messy thing, but you just clean up after. Or you gave her a little spoon and she will learn it. Why do you need people to hold your hand? I know it's the pussification of society, but you need a nutritional specialist and you need a social worker to raise your own fucking child. You live with your mom who has a foster kid. She couldn't help you? No, I was going through the timeline, how I taught my kid to eat herself. I didn't have, yes, we had some nurse come home to us every, I don't know how many weeks apart to measure the kid and make sure, and asking us, oh, what do you feed them? Well, some applesauce or we made some porridge or something. Sounds good. Rock on. She's growing. She's healthy. At 15 months old, this kid should just be getting some bread with some cold cuts or whatever you put on it and sit there and put it in their own mouth. And when they can't figure out of it, here comes the plane. Open the hanger. Here's a spoon. Try get it in your mouth. Please don't knock it over too much. It's not rocket surgery. Everyone who is alive today survived being 15 months old. Most of them without the early invention development center getting a lot of money out of your pocket by telling you, oh, you better buy extra services. His problem is he's like those dummies at the gas tank. Hey, you want to buy an extra chocolate bar? Yeah, sure. And then you buy an overpriced chocolate bar. He was told, oh, you better buy this service we have. Yes, I do, because I'm a shitty dad who doesn't have any natural instincts. For fuck's sake, I hate this guy. Yeah, good thing we are already reading that, but thank you for notifying us. Tell everyone. They can hear it here with us and hear my shit being lost over it. Prior to the birth of the child and while mother was pregnant, father attended all OBGYN appointments with mother. Father also attended in-person mental health appointments for the mother during her pregnancy to ensure both her and the baby's well-being. Since the child was born, the father has attended a vast majority, if not all, of his scheduled pediatric appointments prior to the parties' separation. When the father was not working to financially support the family, the father was at home taking care of the child. Fuck you, you were smoking weed, you fucking piece of shit. And why are you filing this? Because this is also in your last filing. After the child was born, the father took 3 weeks off of work to be home with his child. Mother's assertion that she was the child's primary caregiver during this time is simply not true. The parties were both actively involved in caring for the child. In fact, the father was responsible for the lion's share of caregiving, as the mother would often tell the father to care for the child because she would become overwhelmed and claimed that she couldn't handle it. Sure, bro. You scream that you were the lion's share. Well, we'll find out, Angel Wishes, what he claims. Mother states that at the time she was served with a 209A, the child was only 4 months old and she had taken maternity leave during the period of 4 months and 2 weeks, February 16th, July 4th, while father worked as a firefighter. Perplexingly, mother fails to acknowledge that on March 9th, less than 1 month after the child's birth and during the period of time, the mother was involuntarily held at Lawrence General Hospital pursuant to MGLC 123, that's the rule 412, after exhibiting violent, aggressive, and erratic behavior in the presence of the then 3-week-old child, which prompted mother's stepfather to call 911, as is described in detail in plaintiff's verified motion for further temporary order. As a result of this situation, the mother was placed on administrative leave from her job as a North Andover police officer, as such to state that she was on maternity leave from and after the child's birth and through such time that the father sought and obtained the 209 abuse prevention order is simply not true. That wasn't what she said. That's absolutely not what she said. She said that she voluntarily went to the hospital and then she was put on leave. Didn't we just read that? Haven't we just read that she said she was put on leave and that's why she had to be cleared to come back? I'm not going to open it up, and if anyone is reading along at home and can open up Kelsey's, I'm pretty sure she stated. So perplexingly, it's perplexing me that you perplexively didn't read that she said she was placed on leave. Why would she have to be recertified if she wasn't on leave? Mother further states in her affidavit that not a single provider has had concern about my attention or caregiving or safety of my son with me. This is blatantly false as demonstrated above. The attending physician at Lawrence General Hospital and the town of North Andover's community support coordinator, Crystal Clooney, who was also present at the hospital that night, determined that due to mother's erratic and violent behavior, mother should not be discharged and that she was not in any position to care for a baby at that time. According to the attending physician, mother had experienced an episode of psychosis at home. Yes, she absolutely said that in her motion. And again, this is such a bullshit move. You are taking one night where she was on a 12-hour stay at the hospital because she had an episode, which she then sought treatment after and claiming, well, she can't take care of her kid. Why didn't you get her any help? Why didn't you get her hospitalized? Why didn't you remove the child before that? Why did it have to be after your Jack and Jill party, where you probably were trying to fuck everything that had a pulse? Even more perplexing is that mother refers to an assessment by Dr. Jill G. Durant, a North Andover licensed psychologist, from May of 25 that cleared mother to return to work, yet mother never addresses in her motion what had caused her to be placed on leave, despite several requests for the same thorough, both formal and formal, for the same through both formal and informal discovery. Father's counsel has yet to receive a copy of this evaluation. Jemima, can I trouble you and you can go and look if she didn't say that she was placed on, because this is fucking annoying me now. Mother appears to be relying on this assessment of evidence of her solid mental health Yet also fails to address the fact that approximately 1 month after this assessment, and as mother testified under oath at her criminal trial approximately 1 month ago, mother held a gun to her head and pulled the trigger with the intention to kill herself, all while she believed the child was just downstairs. What? Mother appears to be relying on this assessment as evidence of her solid mental health, yet also fails to address the fact that approximately 1 month after this assessment, and as the mother testified under oath at her criminal trial, yeah, because you took her baby away and she had a momentarily, for fuck's sake, she does address it. She does address it in her. Have you read her filing? I just read her filing. She does admit she held a gun to her head and her child was not downstairs. You took it out. Well, your sister did because you're not man enough to take care of your own fucking baby. You piece of shit. Immediately following the mother's Section 12 hold, the town manager of North Andover permitted the father to take voluntary paid leave for approximately 1 month so that he could stay home and be with mother and the child. During this time, the father was home 24/7 and was the child's primary caregiver. I want to see the surveillance tape for that period to see how much time he spent smoking weed in that month. Yeah, not just her baby, everything, even this dog. Mother asserts that her own doctors and mental health providers indicate that mother's mental health is solid and there is no concerns of her ability to parent the party's son or his safety when with her. It should be noted that the father has yet to be provided any information relative to the status of mother's current mental health. Mother also asserts that she is in the care of mental health providers. Mother has a long history of mental health issues, and it is entirely unclear to the father and the court what her mental status is and what treatment, if any, mother is currently receiving or has received since June 30th. Which long history of mental health issues is she suffering from? That has never been brought up. Never. Other than she had the big sad. At the time the mother pulled the trigger, the child was just outside. Yeah, we know that with Courtney because, yeah. On about December 9, 2025, the father served mother with a first set of interrogatory propounded by the plaintiff to be answered under oath by the defendant. In interrogatory number 6, father specifically inquire into any health and or mental diagnosis conditions that mother is currently suffering from, the healthcare professional she is currently consulting and or treating with for these conditions, and whether she is currently prescribed medication in connection with any of these diagnoses, and the type and dosage of such medication. Mother failed to answer interrogatory number 6, instead stating she will provide an answer to this interrogatory once her criminal trial concluded, which is her right. Mother has yet to provide any supplemental answers to interrogatory and or responses to request for production of documents that she objected to on the basis of the Fifth Amendment, despite indicating she would do so after the criminal trial, which ended on March 26. Mother has also indicated in her answer to interrogatory number 10 that she is and or have been in therapy with Dr. Paul Seisel, Dr. Meisel at MGH, and Dr. Nishevich. Father has not been provided with any other information relative to mother's counseling, mental health, and alcohol drug treatment. And why is that? We just read Kelsey's motion. Kelsey have served Justin with a confidentiality agreement that Justin has never signed. Why? Because let me just ponder why. Remember when all of this broke out? The first rumor I heard was someone was trying to use people online to make a narrative about Kelsey. Someone allegedly, I don't know if it's true, was spending money on having YouTubers talk shit about Kelsey or twit-twatters or whatever it is. Maybe, just maybe, by having Tim Bradle, Aidan Carney's lawyer, maybe, just maybe, they know what social media can do. And that's why they said, we'll give you the mental health records, but they're going to be sealed. And you're going to sign a confidentiality agreement. Why don't you mention that? Why don't you mention why you wouldn't sign it? Exactly. You haven't done your part of it because you know if there was anything in there, not even anything that you could allude to be in anything, that would have been on twit before the day was done. Did he even read? It's not him, it's his counsel. But no, it seems like this is just regurgitating what they wrote in the last motion. It's just the same. Just that, she never answered any of the questions we raised in the last one because it was fucking bullshit back then as well. Well, she has to give her medical reasons, medical records to him in a custody battle, most likely, but you have to get them so you can't share them with anyone. Didn't he go into her medical records when he stole her laptop as well? From these two motions, Kelsey is trying her best to work with him, but he isn't going to work with her. Love your baby more than you hate her. Child needs both parents, if at all possible. Angel, you are correct. Mother has candidly and publicly acknowledged her mental health struggle and has made no indication that she believes that father does not have the child's best interest at heart, because you don't do that in a custody battle. Because then you are antagonizing the other side, like you are now. Mother has also acknowledged the impact that her postpartum struggles had on both parties. In fact, Mother wrote the father a handwritten letter. We all know this. We all know this. She replies to it in your... Is this just the old motion? Have they filed it again? I have read this before. Father, a handwritten letter which, upon information and belief, was written around the time that father sought and obtained the 209 abuse prevention order that explicitly acknowledged the impact that her postpartum struggles had on both parties, and wherein the mother states that being a parent is one of the most overwhelming experiences of my life. I agree. Nothing tests you like having a kid. Mother's mental health issues span before, during, and after a pregnancy. However, upon information and belief, Mother was diagnosed with antepartum psychosis. Father only just recently received a copy of this letter after the conclusion of Mother's criminal trial. Jemima, can I ask you a question? You went to Hank Breenan's law school. A motion to reply to a motion, doesn't that have to reply to the motion? All of this I read in the last motion. The mother just stated that this is way before, and Justin found it on the kitchen counter. And now they are back telling the same story. No. They didn't even put in a mother alleging that she gave it to him before is blatantly false. Nothing like that. No. They are writing exactly the same thing like last time. Yeah, it's just copy-paste shit. Mother acknowledged in the letter that she's been using the father as a personal punching bag. That's metaphorically, most likely. That she was aware that her action has caused the father undeserved pain and confusion, that she had taken her anger out on father, and that father is the most patient and amazing man she has ever met. Well, Kelsey, I bet you the next one will be better because you're not this dumb again. Prior to the child's birth and while the mother was pregnant, the father begged Mother to go to the crisis center in Lawrence, Massachusetts to seek mental health treatment. Father personally accompanied her to several appointments there. Father makes sure that mother scheduled and attended every OBGYN appointment during this time as well. Father took every step that he could to get her into therapy and psychiatric treatment and to ensure her safety and the safety of the unborn child. Father encouraged her to attend an inpatient mental health treatment that lasted approximately 1-2 weeks, but she consistently refused and told Father there was nothing wrong with her. Eventually, Mother did attend one online group therapy session. All of this I read in the last one. However, she then withdrew from therapy and refused to attend any additional therapy sessions, despite Father's repeated requests. Further, Mother's assertion that she has a history of not being a danger to others, has never harmed the child, and never been threatened to harm the child could not be further from the truth. As is detailed extensively in plaintiff's verified motion for temporary, Mother unfortunately has a long history of threatening to harm herself and others, and has inflicted physical harm on Father and several others identified individuals over the last couple of years, both before, during, and after a pregnancy. That demonstrates that she's not currently capable of properly caring for a 14-month-old child without professional supervision. To summarize a few examples, Mother has prior arrest and charges related to kick the father in his genitals. He needed that. I'm sorry. All of this is the same bullshit. They're just throwing more allegations in against her in this. Punched her friend and bridesmaid Michelle Mitchell in the face out of the blue in 2023. Prior suicide attempt in high school. She just in her motion said, I have never tried to do that. The Michelle Mitchell was because Michelle Mitchell attacked her, physically assaulted 2 of her former boyfriends. No. 2 of her former boyfriends. All of this is what was in the first motion. Forcefully slapped the father on his back in 2024. I just hurt myself. Threatened to kill herself while pregnant on multiple occasions, both in writing and verbally. Give me the fucking letters. Pinched father's leg while on a plane as hard as she could until he had to pull away. Well, you should have pulled away before that baby got in there. Destroyed property. Thrown things. Punched and slapped in face and his body. Kicked the father in his genitals. Held an 8-inch knife to her stomach while pregnant. Held an 8-inch kitchen knife to her head while pregnant. Texted the father while she was pregnant. He was at a wedding. She hurt herself. And keep in mind that the baby feels what I feel. Screamed and swore on the father while in presence of the child. Fell asleep with the child in the party's bed. Fucking everyone has done that, you piece of shit. Drove at high speed. I'm sorry. I can't read this without losing my fucking shit. This is exactly the same motion they filed the last time. All of this is the same. There is nothing. Assaulted several of her friends and bridesmaids at the party combined batch, blah, blah, which included throwing a full-sized metal standing club. Yeah, we read all of this. We read all of this. All of this is hearsay. All of this is... Do you have written statements from her boyfriends of all that she had done to them? Oh, this is new. All of these situations involve the mother putting herself, the child, the father, and others in direct risk of harm. Well, if we believe you. Mother's assertion that she has a strong record as an upstanding citizen and police officer is of solid character and has a history of being quality, responsible, careful, and mentally and emotionally competent person to perform her role as a police officer, protect and serve the public, and not a danger to others. Which wasn't in the motion. This is also from the last one. She didn't even mention it. But it should also be noted that following the incident on June 30th, whereby the mother suffered a gunshot wound to the chest while being served with a 209A abuse prevention order, the DCF opened a case and supported a finding of neglect against the mother. The case was ultimately closed based on the father being awarded custody and the mother having no contact with the child pursuant to the terms of the 209 Abuse Prevention Order. So the DCF opened a case against her when she was in prison. No, at this point, she was in hospital because she was wrongfully shot in the chest because a piece of shit sperm donor sent the police to her house. And Noonan just couldn't wait to get this bitch hold on a Section 12. If he was actually concerned about that child's safety, he would have picked up baby C at the park and then filed the RO. That's when I turned 100% against him. If he was really concerned, he would have taken baby C on the 29th when he was at the house, and she said, "Can you take him? Can you hold him?" And she had to force him to do it. I took my truck to the mechanic for making a horrible noise. He removed the Danish rock band CD, all fixed. You must have been listening to Volbeat. Thank you so much, Zach, for supporting the great Danish band Volbeat. He's a liar. If she did all of this, then why leave the baby behind when he moved out? Exactly. Exactly. Further, Mother's assertion that she is clean and drinks no alcohol is curious, especially given the fact that Mother was recently observed drinking alcohol at a restaurant at Newburyport, Essex County, Massachusetts. Oh, you got your little snitches out, do you, you little fucking bitch? Do you know what, Justin? It's absolutely okay to have a glass of alcohol. It's also okay after have been in prison for a year and finally be out of shackles, because she doesn't have responsibility of a child. You took that away from her, didn't you, you fucking little piece of shit? It's okay to go out and have a glass of wine. Maybe have 2 glasses of wine. Hey, go wild. Hook up with some dude. Get motorboated. You're allowed to do all of that. I want your hair follicle tests. I want to see your alcohol. She's not abusing alcohol, and she's clean and drinks no alcohol. This is from the prior motion. This isn't from the new motion. The new motion just states that her hair follicle test came back clean. And again, which law is against having an alcohol, drinking alcohol at a restaurant after the criminal case? There are no provisions in the 209 stating she can't have alcohol. I hope she doesn't have any abuse problems or anything. Of course I do that. But this is just such a bitch move. Mother has a lengthy history of abusing alcohol before and after she gave birth to the minor child. In fact, as detailed and extensively, we heard that in the last one. After the child, drinking continued to be an issue. We heard that she was drinking alcohol daily and drinking and driving, and she couldn't do anything. All of this is just regurgitation of the last motion. There's nothing new in it other than now they can put in she had a drink at a bar. Can I ask a question? When you're such a fucking drunk that you're driving around intoxicated all the time, and you have all these people because you need mental health training and you go to mental health hospitals, no one notices that you are drunk. No one is concerned that you are hammered with your baby. And your baby daddy, this outstanding piece of human man flesh, doesn't take your baby and move out of the house and says, this is not safe for our kid. Nowhere until we heard these motions has it been alleged that she had a drinking pool problem. Nowhere until we found out that Justin has a little bit of a problem did it ever come up that she was drinking heavily. I hope she didn't. fetal alcohol syndrome is a horrible thing. I hope she doesn't have an alcohol problem. But if I had to stay with an alien, I think I would be drinking too. Well, let's get her hoe on. If she was truly an addict, she would have drank during her pregnancy. Most don't stop just because they get pregnant. No, most women will put away cigarettes. They can abstain from cigarettes. But if you're an alcoholic, your whole system, even though it's hard staying off the nicotine as well. But again, all of this is stupid. They would have known at birth if she had drank through her pregnancy. Yeah, the baby would have shown signs of it, most likely. Yeah, why didn't he do anything? Nothing. I noticed he hasn't said she drank during pregnancy. She had such an alcohol problem to be provable in the baby. Exactly. And this is just the same shit. This is the story about how she was naked on the floor. He vehemently denies mom's allegation that father has or ever has had an addiction to alcohol and had used non-prescriptive drugs. Do I still have this on my... Where did I put that? Did I delete them? Am I this dumb? I might be this dumb. I did delete it. Dumb. I thought I put it in the video section. Well, I'm stupid. Oh, that's my grandson. I'm not going to show that video. Well, we have all seen him in the little shed. What type of non-prescription tobacco were you using then? Father recently underwent 2 hair follicle tests and has tested negative for all substances on both. Father will produce copies of his test results upon the court's and mother's counsel's request. Father never drank alcohol during his working hours and never suffered from shaking due to alcohol withdrawal. He denies all allegations relative to possessing, obtaining, or consuming non-prescriptive drugs. Father has never taken mother's prescriptive medication. Mother alleges that father has paid a known cannabis dealer at various times. In support of this allegation, she produces screenshots of father's Venmo transaction to an individual named Robert Moore and attached them as Exhibit C to her motion. The screenshots indicates that October 11, 2025, father made 2 payments to Mr. Moore in the amount of $10 and $15. That day, father was attending his college roommate's wedding in Maine. Mr. Moore was the bartender at the wedding and had a Venmo QR code that patrons could scan and send him tips through Venmo. These transactions had nothing to do with purchasing cannabis or any other substance. It was merely tip money. He's a good tipper. Father also denies ever borrowing cash for the mother to purchase marijuana. Mother further alleges, now this is new, further alleges on Christmas Eve, she observed father obtaining and snorting Adderall at his parents' house. Again, this never happened. In fact, father worked a 24-hour shift on Christmas Eve in 24 and was not even present at his parents' home. Mother's attempt to paint father in such a negative light is peculiar, particularly given that for the past 10 months, father has been successfully raising the child as a single parent, during which time the child has flourished and continues to do so, with the help of your parents. He also vehemently denies ever breaking into the property located on Phillips Road, removing any of mother's belongings from the North Andover property, ripping out or damaging any surveillance system, removing evidence from the property, wiping or accessing mother's laptop or iPad, stealing cash or gift cards, accessing mother's social media accounts, email accounts, bank accounts, and pension accounts. Father does not even know mother's passwords to these accounts. On July 3rd, when father entered the property to retrieve his own personal belongings and the child's, he only did so after seeking advice and the permission of North Andover Police Department. No. You were allowed in there if you could open the door. They didn't say kick down the door, you fuckface. When he was gathering the belongings, he was accompanied not only by North Andover police officers, but also mother's father. According to Officer McCody's police report, he found that there to be no issue between the father and mother's father, and both parties clearly desired to make the process as efficient and peaceful as possible. McCody further reported there was no mention of breaking and entering by either party at the time. And then father and mother's father embraced in a hug and had emotional conversation, which ended with mother's father stating, "It's not your fault. She is sick. She needs help." See Commonwealth's motion in limine to prohibit questioning regarding claim promise rewards and inducement dated on March 9th. In fact, the mother's father texted the father a few days later asking the father if he needed anything else from the property. Months went without any mention or allegation anything was broken or stolen. We have you on tape kicking down her door. The father was never arrested. No, because look at the above promises, inducements. At the time that father sought and obtained the 209A, the father was, by all accounts, a resident of North Andover property. No, you moved out of it, which you stated in court documents on the 27th. Father moved in, blah, blah, blah. Blah, blah, blah. The father paid 50% of the mortgage. Father also contributed to the April 24 mortgage payment despite not living. Additionally, during his time, 50%, which you should do. You live at the house. At the time, father applied for the 209 and filed instant 209C matter. The father driver's license listed the North Andover property as his current residence, which is court documents stating you didn't live there. While the father acknowledges that he listed his parents' address on his current residence when he applied for the 209A abuse prevention order and filed the instant 209C matter, it should be noted that the father was not represented by counsel at the time and was handling these matters pro se. Father reasonably believed that both parties subject to a restraining order could not share the same address. Do you have the same thing in America that we have in Denmark? That just because you don't know the law doesn't mean you don't break the law. What a stupid argument. I put my mommy's address down because I didn't know better. I had no lawyer. No, you put your mommy's address down because you didn't want to live with the bad lady anymore. She made you do stuff you didn't want to do. You couldn't smoke weed and do drugs. All of father's and the child's personal belongings were in the North Andover property before the trip to Bethel, which it should be. Mother further assesses that father withdrew approximately $5,000 from the joint account. Again, mother is attempting to mislead the court. In September 24, the party is open. Yeah, there's nothing in that one. It doesn't mean anything. Because it's a joint account, he was allowed to take it. Mother further alleges that father canceled the party's travel reservation, redirecting those funds to his own account. Curiously, mother fails to mention that this travel reservation for the party's honeymoon, which was fully funded by father. Given the recent events and the 209 abuse prevention order, it was clear that the parties were no longer getting married and going on a honeymoon. Father was able to obtain a refund for the Airbnb he rented, but the flights were non-refundable. Mother maintains that the father is refusing to budge on anything relative to the child, which she believes is a deliberate hostile attempt to keep mother from the child, not a protective way, but a controlling way. Over the past 10 months, and as a result of sustaining a gunshot wound after allegedly holding a firearm to her head, not allegedly, this is what the court found, and pulling the trigger in an attempt to take her own life, and following criminal charges for assault with a dangerous weapon, mother has spent almost all of her time in the hospital, prison, and or on house arrest. 1 month ago, the mother testified under oath that less than 9 months prior, she attempted to hold a firearm to her head and pulled the trigger in an attempt to kill herself, knowing that the child was just downstairs. Just rehashing what you put in earlier because you don't really have anything to say other than you can't say I do drugs. That's preposterous. But let me write as many times as possible that this mom, when I ruined her life, tried to kill herself. Because, hey, she's a shitty mom, isn't she? What mom would try and kill herself? The father's only concern over the 10 months has been to ensure the child's emotional and physical safety. To assert that the father is refusing to budge is unfair, false, and inaccurate. Over the last 10 months and in connection with both 209 and 208 matters, the parties have resolved all issues relating to the child through counsel by agreement without requiring the court to intervene and render a decision. These issues include custody, parenting time, child support, health insurance for the child, uninsured medical, dental, and vision expenses for the child, and daycare costs. Funny enough, all of this is only because Kelsey said, it's fine, I'm in prison because of you, you fat fuck. But I will not fight you on this. This is why you have all of this that you can pull out now and say, oh, look how great I am to work with her. You were the one filing the motions, and she was the one accepting them. You didn't budge. You didn't give her, okay, I can take baby C to prison once a month and he can see you. You gave nothing. You took everything. He gave you everything. She was cooperating. You were demanding. The father also agreed to send mother through counsel bi-monthly updates about the child, including his diet, general well-being, development, mental, dental appointments, new activity, blah, 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 blah. Sent photographs and videos as part of these bi-monthly updates, all of which he complied with. When mother's counsel proffers specific question for father to answer as part of these updates, father provided answers to the same. Madison could attend the recent baptism. It's not that recent. Finally, and most importantly, 3 days ago on Saturday 25, the father, through counsel, arranged for the mother to visit with the child's father's counsel office, which marked the first time mother had seen the child since the issuance of the 209 abuse prevention order. The parties and the respective counsel were also present, so she had her counsel with her. Notably, the father voluntarily proposed and facilitated this visit without the need of the court order and formal written agreement. The father acknowledged that it is important for the child to be reunited with the mother, but believes this should be done in a controlled and professionally supervised environment. The set-up parenting plan proposed by mother, whereby she would have one supervised parenting time visit per week for 3 consecutive weeks, followed by 3 supervised visits per week for a period of 2 months, with supervision by mother's mother and or stepfather, and thereafter automatic transition to a fitty-fitty shared parenting schedule is inappropriate, too rapid, and given the facts and the circumstances of this case, not in the child's best interest. It should also be noted that fathers object to using Miss Jenny Tinney, LCSV, as proposed by the mother as the parenting time supervisor in this matter. I don't know who Miss Jenny Tinney is. The child has not been in mother's presence since he was 4 months old, but for the visit on Sunday, that was facilitated by counsel, and as is documented by the child's early invention development specialist, is already exhibiting cautiousness around new people and unfamiliar situations. It is evident by the relief sought by the plaintiff, as well as father's voluntary agreement to arrange for the mother to see the child prior to the motion hearing. The father acknowledged the importance of reunification between mother and the child. That said, father's sole objective is to ensure that any such reunification occurs in a safe, structured, and controlled environment that is responsive to the child's needs and best interest. It is the father's further position that he continues to have sole legal custody of the child at this time until further agreement of the parties. Our court order. This verified opposition is further supported by such arguments that may be advanced by counsel at the time of the hearing. Wherefore, the father respectfully requests that the court denies mother's motion for further temporary orders, and as outlined in the plaintiff's verified motion for further temporary order and plaintiff's verified motion for the appointment of a guardian ad litem, respectfully request that this court orders as follow. The father shall continue. I'm going to move up to be the baby C should stay with the father. His full date of birth was there. We don't need that. Mother shall have weekly supervised parenting time with the child 1 time per week for up to 5 hours at the Center for Achieving Balance for Children located at Medford, Middlesex County until further agreement of the parties or court order. Mother shall be responsible for any and all costs relative to supervised services. The Supervision Center shall comply with Massachusetts Probate and Family Court Standing Order 1223, which incorporates the guidelines for professional parenting time supervisors, including but not limited to maintaining observation notes, reports, and supervised parenting time logs, which shall be provided for counsel for the parties. Both parties shall be prohibited from posting. This is the same as the last time. She's going to need mental health treatment, and she needs a 14-panel hair follicle test within 5 days of the issuance of this order to test for drugs and alcohol. Mother shall provide father through counsel the result of said hair follicle. Why do we need this again? She has just given you one. The parties shall forthwith download our family wizard. You didn't do that, you fucking idiot. Why did you put this in when you didn't respond to her? That a Category E guardian ad litem be appointed. All of this is the same as the last time. By Justin Alien. Peter J. Heiko. I was singing the praises of Kelsey and her counsel for writing a good lead-in to their motion. All of it was, I have tried. I accept the father has a role. I accept that I'm not going to get him back instantly. I just want to work. I gave Justin everything while I was in prison because of my situation. I have done whatever I could do to facilitate a good environment for this co-parenting. But now I want more time with him. And Justin is an asshole. What did they reply with? The same shit they already had. Why didn't you argue why you didn't use our family wizard? Why didn't you argue that? That's a pretty big thing. He has tried to establish contact with you. You demand that she download that. She even offered to pay your access to it. And you ghosted her. You still haven't. I bet you he will have it tomorrow when we go to court. Oh, I didn't, it was an accident. And you're sitting there shitting on her for being a massive alcoholic because you saw her having a drink at a bar. Well, I'm sorry. If I had been through 9 months of hell, even though I didn't have my kid back, I might have dug into what I have over here. You didn't reply to any of the allegation or counter allegations she made about how you treated her, how all of what you said was lies. You just said the same stories one more time, lies or not lies, I don't know. It's a he said, she said right now. Funny enough, all of it except the Jack and Jill party, there's no real witnesses to any of it. And then you lied about her claiming that she had been on maternity leave when she clearly states that she was put on leave because of her postpartum depression. How can a lawyer do this? Kelsey Fitzsimmons will be in court tomorrow at 10 o'clock. There is at this time, no available feed. We have been in contact with court. There will be no Zoom call. And I love that they bring up, well, remember this kid is afraid of strangers and seeks the dad because that person at that center said that, so she can't be with her baby. That's exactly why she needs to get back with her baby. I agree. It's the slow baby steps. But doing that shit that you do, oh, she can see him for 5 hours every now and again. That's not going to make a connection between them again. I agree. Going to a 2-2-3 now, way too soon. That would be bad for the baby. Said it yesterday on Masa, going straight to a 50-50, and that's not what Kelsey asked for either. Straight for a 50-50. Don't do that. That's just us taking Justin away and giving the baby to Kelsey. That would be just as wrong. But you need to give her at least bi-weekly time with her kid for multiple hours on their own, not in some clinical environment where, oh, he just made a sound. I'll write that down. Oh, he just made a sound. I'll write that down. Because she doesn't get to connect to her baby. All of this was a character assassination on Kelsey. What Kelsey did was write, I have tried. I have reached out. I have given everything. This bullshit artist does nothing. And we have you on fucking video smoking. Who do I believe? You who claims that Kelsey was a massive alcoholic, or Kelsey, who I have seen a video of you laying on your living room floor because you were so drunk you couldn't stand up. I have heard how you talk. And I have to admit, yes, I thought that Kelsey sounded a little inebriated herself in that video, but then I heard her in court. And I think it's because she has veneers on that she found a little. That's the way it changes when you have veneers on. But I know you were fucking drunk in at least 2 occasions. And I know I have had 5 videos where you smoke some kind of substance. I know she alleges that you hid mushrooms in her car. Good for you if you have been clean and you have given them clean hair test, so you have changed your life. Good for you. Imagine that you had to get your baby mama shot to turn your life around. It wasn't enough for you to have a baby. Is your mom making sure you don't do drugs? Allegedly in Minecraft. Jen, you wine. Thanks for the double duty today. Well, it became triple duty. Duty. Well, thank you, Genuine. Yeah, and that's what and I think this is why I'm so angry. Because reading these texts, this guy is not a dad. I hope he's become a dad. Yeah, I know Michael have said he will be there, but I don't know if he will have a feed. I haven't heard that. But what I think is Justin is not a dad. I hope he has become a dad by having the kid now. But he wasn't. The man I heard in those recordings, and I know it's a snapshot of what goes on in a relationship. Have I always been talking nice to my girlfriends? No. There's a reason why I'm a divorcee. Because we would lose our temper as well. Probably wasn't funny living next to us those days. I have screamed at my wife in front of my kids. She has screamed at me in front of our kids. That's why I decided I have to leave so the kids doesn't have to grow up in this every single day. That was a tough decision to make because you will stand there and think, I can take more of this and I will have my kids. But then you look at your kids and you see your 2-year-old cry every time they hear mom and dad talking because she knows they're going to yell at each other again. That's not good for a baby. That's why I took a very, very tough decision and left a 3-month-old. It wasn't easy. It wasn't nice. But I put myself on the back burner. I gave her everything. Everything that was inside of the house, she had to keep to run the family. I would start over. For the next 16 years, 15 years, I drove every chance I got, roughly 10 hours every weekend. 2.5 hours up, 2.5 hours home. So I could spend as much time as I would have possibly with my kids. Any vacation I could get, any special days, anything I could get them, I took them. Because I was still their dad. And I was just with my oldest daughter for 5 hours Saturday and my grandson. I just spent over an hour talking to my youngest daughter on the phone today about everything and nothing. I love that we are so comfortable with each other that they confide in me, that they call me if they have anything. As they say, we like talking to you because you are the same every time. And I said, yeah, if you want emotions, call your mom. I'll be emotional later. When my daughter called me and told me I was going to be a granddad, I was talking to Valhalla on a stream, after a stream. And I am a little softy when it comes to it, but I don't show it to them because I'm their rock. And I said, yeah, whatever trouble comes along the way, I will help as best as I can. And I will never be the one that will sit and cry with you. I will fix things. I will call a lawyer. I will call whatever you need. But that's why I have a pillow. Because then I go in and I cry into my pillow. And I'm sorry that I can't fix the world for my kids, because you can't. But you can help them as much as possible. This is why I get mad when I read this, because I fought tooth and nail for every single second. But at the same time, I knew, even though I didn't like their mother, she was a good mother to them. And that's the most important part in all of this. She was not a good wife to me, and I was a really bad husband to her. But I think we were okay parents. Have we yelled at each other a lot? Yeah. Have I had days when she called me when I just hung up? Abso-fucking-lutely. Because I found out that she just called to get into fights. And then I just figured out I'll turn off the phone and I'll call 5 hours later and said, oh, sorry, I lost signal. What did you want to say? Kind of fixed it. I still see her and I'm cordial with her when we meet each other because we did make the 2 best kids in the world. So something was right. At some point, we did something right together. I have yelled and screamed about her, but I've never badmouthed her to the children when they were small. If they come now and complain about something, I'll be honest with them. I won't give them everything. But I have never, ever, not even when we had to go to court over custody, never done what Justin have done. This is bullshit. You didn't reply to anything that she alleges, other than I don't do drugs, but she's an alcoholic. Oh, she had been arrested multiple times. There's nothing on her record. She was a fucking police officer, you piece of shit. Well, she beats everyone. The one she allegedly punched apparently said that she punched her first. Baker, you're a wonderful dad. I can tell your anger towards Justin's BS tells me so. I love you honestly. Well, we need to be honest sometimes, even as content creators. And this case really, really gets to me. Karen Reed, I was angry on the system. But in this case, I'm angry because the baby needs its mom. Needs its dad as well. I will not take the baby away from Justin just to get revenge. Because that's just as unfair. But they have to fucking grow up. And I saw a grown woman in that motion. And I saw a little boy in his motion. So, I hope tomorrow we will get an agreement that he can't keep gatekeeping the baby. This baby is not a tool to get revenge. No baby should ever be a tool to get revenge. Hate him with a passion. Hate her with a passion. Tell everyone she's the biggest cunt that ever walked this planet. Just never, ever tell your baby that she is that, if that's how you feel. If you think that he's a skank, tell your sister. She probably knows how a skank is. But never tell your baby. And Kelsey, when you get to see your beautiful little baby boy again, never, ever say a bad word about his dad. You made him together. Gonna raise him together. And you have to be grown-ups together. I totally agree, Restless Mom. That's the hardest part of having children. It's when the real world have to make us be adults, because the easiest thing is just yell and scream at the other one. But we have this little piece of joy that they made together. Put him first. And I see in Kelsey's motion, that's what she wants to do. What I see in Justin's motion is, I want to hurt her again. And I don't like that. I sincerely don't like that. But it's 12:30. I'm an old man. Now I'm gonna go kick my pillow, get some sleep. You have to do without me tonight. I'm not doing a late night stream in 5 hours. I'm gonna get some sleep. Don't date the bad guy. Use him for fun. Find the boring, stable one. It's better in the long run. Because bad boys are for fun. Crazy girls are for fun. The rest, when you have to raise a family, stability is the key. Sorry it took so long, but I hope you enjoyed it. Let's have our fingers crossed for tomorrow.
I'm Jimmy. How y'all doing?
You know what?
Yeah.
I went to you first before you.